Hello?
Yeah.
Are you guys doing a mic check or are we good?
I can hear you loud and clear.
Good morning, everyone. We're going to begin shortly. I'm going to count down 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. We can begin.
The Judiciary Committee will please come to order, a quorum being present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. I would like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you would like to submit materials, please send them to the email address that has previously been distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I'd also like to remind members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as the committee markups, except when recognized to speak. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 5374, the Stopping Harmful Officers on Platforms by Screening Against Fake Email E-Commerce Act, or the Shop Safe Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5374, to amend the Trademark Act of 1946 to provide for contributory
Without
liability.
objection, the bill is considered as read and open for amendment at any time. I will begin by recognizing myself for an opening statement. H.R. 5374, the Shop Safe Act, is bipartisan legislation that will have a significant impact on the safety of consumers when they purchase products online. It would place greater responsibility on online platforms to help police counterfeit products sold by third parties on their platforms by incentivizing them to implement certain best practices designed to keep counterfeit products off these marketplaces if the health and safety of consumers is implicated. I'm pleased to lead this bipartisan bill together with my colleagues, IP Subcommittee Chairman Hank Johnson, IP Subcommittee Ranking Member Darrell Issa, and Representative Ben Klein, a former colleague on this committee. The Shop Safe Act takes a measured and balanced approach to address this serious and growing consumer safety concern. In developing this legislation, we have drawn from industry recommendations and the robust input of a variety of stakeholders over the course of more than 2 years. I am pleased that this effort has earned the broad bill bipartisan support. On that point, I want to thank Mr. Johnson and Mr. Issa for their leadership on this issue in the IP subcommittee. They have engaged in shareholders throughout this process, including holding a hearing on the bill in May, followed by a series of roundtables over the summer in which stakeholders had additional opportunities to offer feedback on the bill. I know that this bill is a priority for them, as it is for me, and I am pleased to have worked with them on it on a bipartisan and collaborative way. I also look forward to continuing to work with them and other interested members to refine the bill as it continues through the legislative process. From toys to contact lenses to cosmetics, no industry is immune from counterfeiting. While attempting to appear legitimate to unsuspecting consumers, counterfeit products avoid the health and safety standards with which authentic products must comply. What results? Counterfeit airbags that deploy fractions of a second too late, counterfeit bike helmets that break in half upon impact, counterfeit batteries that explode from poor construction, and counterfeit toys that break into small pieces that can be swallowed by young children. The internet and e-commerce have revolutionized the way products are marketed and sold. A decade ago, just over 20% of Americans reported making purchases online. Today, nearly 80% of Americans have made purchases online. Americans spend more than $790 billion in e-commerce in 2020. Driven in part by the global COVID-19 pandemic, online sales to U.S. consumers were up more than 30% in 2020 over 2019. At the same time, the products Americans were purchasing online were exactly the type for which compliance with health and safety standards are most critical: masks, gloves, and cleaning supplies, for example. Unfortunately, counterfeiters were quick to move in, too. Reports of counterfeit personal protective equipment and other COVID-19 essentials sprung up almost immediately. Whether purchases made online or in a brick-and-mortar store, consumers must be able to be confident that what they see is what they will get. In a brick-and-mortar store, a consumer can see firsthand what they are purchasing. And the liability structure for brick-and-mortar retailers incentivizes those companies to thoroughly vet their supply chains to ensure that the products they sell are authentic. In the online world, however, without the benefit of the look and feel opportunity before purchase, consumers are at the mercy of the accuracy of the online listing information and the scruples of the seller. Consumers may never become aware when they have purchased a counterfeit product, particularly if a sales listing included misleading images of the authentic product or fake reviews that made the listing appear more legitimate. Unaware, that is, but still susceptible to the worst-case scenario in which a product they believe to be legitimate actually poses a threat to their health or safety. One of the principal problems in the current legal regime, relying on a notice and takedown regime, is that it is unduly reactive. It is not until a listing is up, perhaps for some time, that a brand owner can modify the platform of the concern. During the recent hearings on this bill, one witness who litigates in the area of counterfeit goods explained that it is not uncommon to encounter sellers using false names and contact information when operating their third-party storefronts. She explained that many overseas counterfeit sellers and e-commerce marketplaces operate as if they are untouchable. The reliance on the current notice and takedown system for policing counterfeits opens the door for an unsuspecting consumer to buy a fake product instead of the genuine one she thought she was purchasing. To address this problem, we need both the brands and the platforms to work together to limit and prevent the sale of dangerous counterfeit drugs. As a result, the Shop Safe Act takes a balanced approach to the problem. Recognizing that online marketplaces operate differently than brick-and-mortar retailers and offer distinct advantages, particularly to smaller sellers, the bill does not impose the kind of direct liability applicable to brick-and-mortar stores. But it does require more of online marketplaces than they must do now. It requires them to undertake a series of common-sense steps to ensure that they know the sellers they allow in their marketplaces and to confirm that those sellers provide legitimate contact information. For foreign sellers, there is a requirement to accept personal jurisdiction in the U.S. and to provide a means to accept the service of process. This way, brand owners have a way to seek recourse against a third-party seller who sells counterfeit goods. The bill also encourages platforms to monitor and screen for known indicia of counterfeiting and to keep repeat infringers from reappearing on their platforms. These measures assess a platform's actions from a reasonable standard, taking into account that different-sized platforms will have different resources and capabilities to avoid these efforts. Finally and significantly, the bill includes a provision that addresses the concern that the notice and takedown procedure for reporting counterfeit listings is sometimes abused. The bill creates a new cause of action that allows third-party sellers who have had their listings taken down based on a material false misrepresentation in a takedown notice to recover in a civil action against the person who made the misrepresentation. This important new addition to the bill will further the goal of balancing the equities in the fight against crime counterfeits. It is past time to address the concerns of unsafe counterfeit products available for purchase online. I urge my colleagues to support this important bipartisan legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Counterfeiting harms both American businesses and American consumers. Businesses lose sales of their legitimate products to counterfeits, and consumers receive fake products that may be defective or worse, even dangerous. The threat that counterfeiting poses to Americans is made worse by the fact that more than 80% of counterfeits come from China, where the Communist Party turns a blind eye to this illegal activity because it harms American manufacturers. E-commerce platforms have become a haven for these counterfeiters. Rather than selling fake Rolexes in person on the street, counterfeiters now sell fake Rolexes worldwide from the comfort of their apartment anywhere in the world. Stemming mostly from China, these counterfeiters use false identities, misleading or fraudulent pictures, and information about their products and fake reviews to make it difficult for consumers to distinguish between authentic and counterfeit goods. Under current law, trademark owners often have little recourse when faced with online counterfeiting because the sellers are unreachable in China, and it is almost impossible to hold platforms accountable even if they turn a blind eye. This bill will incentivize action on the part of platforms to innovate and improve the way they deal with counterfeiting. I look forward to the committee's consideration of this legislation today. I want to thank the sponsors. I know Mr. Ice has worked long and hard on this legislation. I want to thank them for their work and for bringing this to the committee. With that, Mr. Chairman, I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 5374, offered by
Without objection,
Mr.
the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. The amendment in the nature of a substitute makes a technical change to the bill's short title, revises the definition of third-party seller to better align that definition with the definition of electronic commerce platform, and makes a handful of non-substantive changes for clarity. I urge all members to support the amendment. Are there any amendments to the amendment in the nature of a substitute?
Mr. Chairman?
For what purpose does Mr. Johnson seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Combating counterfeits online is of critical importance, and my colleague, the ranking member of the Courts and IP Subcommittee, Mr. Issa, said during our hearing on this bill earlier this year that there is no more bipartisan and cooperative issue than keeping unsafe counterfeit products out of consumers' homes. And I could not agree more. The Shop Safe Act has been a true leader and a collective effort with Chairman Nadler, Ranking Member Issa, and Representative Klein. I want to thank Chairman Nadler for his leadership on the bill and Mr. Issa and his staff for their dedicated work to get this bill to markup. We are no longer in the era of fake watches and handbags being sold out of car trunks. As consumers have moved online, counterfeiters have embraced the internet also. But shopping on an online marketplace should come with the same customer trust and confidence as a brick and mortar store, and today it does not. Last Congress, I held a hearing in the IP subcommittee where we heard testimony about the hazards of counterfeits being sold online, often in listings that make it virtually impossible for a consumer to even know that they are buying a fake. I still vividly recall the video one witness showed about what happens if you have your car fixed with a fake car part. Suffice it to say that the impact is truly life or death. The same is unfortunately true for fake electronics or even toys if they are substandard and break or fail at exactly the wrong moment. Brands have been doing their best under the current legal system to keep fakes off these online platforms. While no one wants to see consumers get hurt, brands also suffer the consequences to their reputation if a counterfeit bearing their trademark is associated with harm or tragedy. They cannot do it alone. They need online platforms to share in some of the legal responsibility, and that is exactly what the Shop Safe Act does. In my subcommittee this Congress, we held a hearing specifically on this bill with testimony about it and how it would incentivize platforms to take steps that only they are able to take, like more rigorously and consistently vetting sellers and monitoring and removing those who are found to repeatedly sell counterfeits, in addition to other best practices. In exchange for undertaking these best practices, platforms would be immunized from liability for counterfeit products sold by third-party sellers, a much fairer bargain than the minimal steps platforms currently need to take to avoid the same responsibility. The bill is expressly directed at those products that affect health and safety, the products where the need for this legislation is the greatest. And the bill is drafted to acknowledge that brand owners would continue to play a role in the process. It was important that we get this right, and this bill does that in a balanced and considered way. I strongly support the bill and urge my colleagues to do the same, and with that, I yield back.
The gentleman yields back who seeks recognition.
Mr. Chairman,
For what purpose does Mr. Issa seek recognition?
Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I want to thank you and your entire team for working tirelessly to produce a bill that is substantially different than it was in the last Congress. As you so aptly noted, we have added to it. We have also modified more than 3/4 of the bill. And we did so based on a bipartisan stakeholder meeting process, not just in a hearing, but in countless personal and remote meetings with stakeholders on both sides of the issue. That led to substantial changes in the bill. And I would be the first to say we're not finished, that we continue to listen to those individuals and companies, but we recognize that only when a piece of legislation is moved out of committee do people begin to realize that it has a high likelihood of becoming law, and as a result, they need to make their best and final statements on any additional changes, and I look forward to those changes. For those who are not familiar with this particular legislation, the genesis of this was, in fact, the Tiffany versus eBay decision. In that decision, we were not dealing with a health and safety product. We were dealing with a piece of jewelry. We were not dealing with a question of whether or not it was a counterfeit. It was. We were dealing with what this poster behind me typifies. We were dealing with, there was no responsibility to see, hear, or say by the platform, even though they knew and were shown to know that there were multiple other counterfeits sold by this company, and there had been complaints. They did not know that that particular product was a counterfeit. We attempt to change this standard only slightly. We are not saying that eBay or Amazon or any other platform has to know for sure that that a particular product is counterfeit. But if there is a reasonable standard that they knew that there was an ongoing practice of shipping counterfeits, that in fact they'd bear responsibility unless they take action. Many who feel we do not go far enough complain about the fact that the safe haven is large. And I will agree that the safe haven is large. If an online platform, just like the post office, UPS, or others, is simply completely unaware of what's inside a package and it has not been brought to their attention, we believe they should continue to operate without the risk of being sued. But if, in fact, they become aware and take no action, if they fail to have policies that would reasonably catch a counterfeit, then, in fact, we do shift responsibility sufficient that they can be at peril. Make no mistake, every retailer in America who brings product into their store or location and sells it has this peril already. This is a unique situation in which the online platforms are treated much more like a common carrier when it comes to their liability. We seek to modify that only slightly, and only if these companies do not take reasonable efforts to combat known counterfeiting. So, Mr. Chairman, as you can see, Shop Safe is a work in process. The progress has been significant. I think all of us stand ready to listen today as we go through this process. But I do believe that there is one and only one question that needs to be answered, and that is, Do we have a vast counterfeiting problem, as the ranking member of the full committee said, primarily from China, but not exclusively? Do we have a problem, and does it lead to unsafe product being put into commerce? If the answer is yes, then ShopSafe is in fact the only way we're going to get the kind of progress toward reducing this. So as we go forward, I want to just close by saying this is not a new problem. Counterfeiting has been going on for a long time. Even 20 years ago in my own business of making electronics, I saw a fake product that led to damaged automobiles and even fires in those automobiles, only to discover that the product that was sold and purported to be mine was not mine and was inferior. So it's not that counterfeiting is new, it's that under current law, many organizations who in fact facilitate the delivery of these products find themselves immune from any responsibility. ShopSafe seeks to change that, and I believe it is a good and positive compromise. And again, I thank the chairman for his leadership in this role, and I yield back.
I thank the gentleman. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, I move to strike the last word.
The gentlelady is recognized.
Thank you so much, Mr. Chairman. I rise in support of the ShopSafe Act, and I commend the committee for providing substantial resources to ensure the safety and quality of our products, that they meet federal and state safety and quality requirements. While the primary focus of the ShopSafe is the prevention of counterfeit products that damage businesses, the economy, and most importantly, have an impact on addressing the threatening our consumer health and safety, I was shocked to learn of the number of preventable injuries to children across the country from counterfeit toys. I recognize that in my district, and I know throughout the country, people have gone online more and more to buy and to sell amidst an economic disruption caused by a pandemic. And while I do hear the concerns of the potential impact this bill could have on small sellers, I lend my support to this bill, and I hope to work with the committee to ensure the protections for small sellers within the bill are upheld. As a mother, as a consumer, as a grandmother, I support this bipartisan measure. I commend you, Mr. Nadler, Mr. Issa, Mr. Johnson of Georgia, and Mr. Klein for working so hard on this bill. And I look forward to that kind of bipartisan spirit as we move forward this week. With that, Mr. Chairman, I yield back.
Mr. Chairman.
Gentlelady yields back. For what purposes Mr. Shabbat seek recognition?
Move to strike the last word, Mr. Chairman.
The gentleman is recognized.
Thank you. I want to start out by noting that as ranking member of the Foreign Affairs Subcommittee on Asia and the Pacific, I certainly appreciate the immense threat that China poses to American citizens in all across the board, with whether it's opioids originating from China, efforts to steal our intellectual property, or efforts to flood our online marketplaces with illegal and often dangerous counterfeit materials. It seems that they'll stop at nothing in what they oftentimes do that harms American citizens, small businesses, and our overall economy. Their predatory behavior, recklessness, their callous behavior can be pretty staggering. Back in May, I mentioned the impact that counterfeits have on companies large and small here in the United States, and I think it's worth repeating that sentiment again. Procter & Gamble, P&G, which is a large, well-known company that's headquartered in my congressional district, is one of many throughout the nation that loses billions of dollars, really, each year due to counterfeited and pirated products in the online marketplaces. These counterfeit products not only negative effect on our economy, but also introduce products into our communities which can be hazardous or sometimes deadly to American consumers. Online marketplaces need to do a better job of keeping counterfeit products off their respective sites, as unscrupulous sellers too often appear and then reappear online with counterfeit products without recourse to the buyer who may be put into harm's way by these counterfeit products. With that in mind, as this legislation makes its way to the floor, because I believe it will pass for consideration, it's important to note that there have been some concerns raised by small businesses that sell legitimate products online marketplaces. As a former chair and ranking member of the House Small Business Committee, one of my main focuses has always been to do all that we can to help America's small businesses and not put barriers or unnecessary regulations in their way. While the intended purpose of the Shop Safe Act is to better ensure that consumers are protected from harmful counterfeit products, it shouldn't necessarily do so at the expense of America's small businesses. It's my view that online marketplaces and rights holders ought to act in good faith together to implement industry standard best practices to protect consumers. Additionally, it seems as if the definition of health and safety, the category of products meant to be the subject of this legislation, is overly broad and could result in unclear or misapplied standards on marketplaces, resulting in application to goods which have nothing to do with health and safety. I think that overall this legislation will help to keep dangerous counterfeit products off online marketplaces in the United States. But I hope that the authors of this legislation will consult with small businesses, whether sellers or brands, to further improve it before it reaches the full House of Representatives to the floor for consideration. I want to thank you, Mr. Chairman, Mr. Issa, and Mr. Johnson of Georgia, Mr. Klein, for your leadership and hard work in drafting this legislation, and I yield back the balance of my time.
The gentleman yields back. For what purpose does Ms. Lofgren seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
The gentlelady is recognized.
Mr. Chairman, there's no question that the issue of consumer safety is very real, and that goods purchased online that are unsafe are a very real issue. However, once again, this committee confronts the fundamental policy question of the digital age: how to strike the right balance in intermediary liability for online platforms. In plain English, when and how much should a platform be held legally responsible for the conduct of its users? These are complicated questions, and if we get it wrong, we will have very adverse impacts in the marketplace and potentially miss the mark of what we're trying to do to protect consumers. Now, there are a whole variety. We think of Amazon because it is the behemoth of online sales, but there are a whole variety of digital marketplaces like eBay or Etsy, and also platforms that we may not think of as sellers, but even WhatsApp and other applications that also users can use to sell their used goods. So I do think we need to approach this very carefully, and while I laud the objections and the intentions of this bill, I do agree with the gentleman from Ohio that there are some definitions that need to be tightened up. I do not intend to offer any amendments this morning, but I do hope, and I appreciate, Mr. Chairman, your willingness to work with me on some of the issues that have been raised by scholars about these, and I look forward and hope to continue to work with you between now and the floor. I would like to mention that the broad approach taken and the definitions that are somewhat vague could pull in everyone from an internet user who is selling something, used clothing of their own, to people advertising lawn sales and garage sales. I know that is not the intent, but I think a fair reading of the language could sweep that in. Some, in their analysis, believe that the only platform that actually could afford the liability that this measure would afford is Amazon, and that all of Amazon's competitors would actually have to disappear based on the liability issues in this measure. Clearly, that would not be the intent of this committee, but it would be an outcome I think would be very adverse for the United States. Finally, I would like to know, rather than go in all the details of the concerns I have, I will place my questions and issues in the record so that we can all discuss it between here and the floor. And I would like to put into the record a number of communications I have received objecting to the legislation, including letters and blog posts from Engine Advocacy, the Chamber of Progress, CCIA, the Coalition to Protect Small Sellers, the Internet Association, the Electronic Frontier Foundation, Tech Dirt, which is one of the most insightful blogs on technology policy, and a letter just received from the National Retail Federation opposing the legislation. And finally, an analysis by Professor Eric Goldman, who is a law professor at the University of Santa Clara, who goes through in what he describes as wonky detail of some of the issues in the bill that need to be addressed, and I believe can be addressed. So I look forward to working with you, Mr. Chairman, and with the author and the ranking member of the subcommittee so that we can have a measure that hits the mark but doesn't hit who we don't want to hit and continues to allow for a robust marketplace in the digital arena. And with that, Mr. Chairman, I see my time has expired and I yield back.
I want to thank the gentlewoman from California, Ms. Lofgren, for her effort to continue to work on perfecting the bill as we move it to the floor. I know Ms. Lofgren agrees, as do I, that counterfeit goods, particularly those involving health and safety, are a significant problem. And we both agree that we want to continue to improve this bill on a bipartisan basis wherever possible before we consider bringing the legislation to the floor. My staff and I will continue to work with Ms. Lofgren and her staff, as well as with any member of this committee, on a good faith effort to craft legislation that will finally move the ball forward in this complicated but critically important issue. There is no doubt that the internet and the e-commerce it facilitates are the direction of the future, and we must ensure that we get it right for consumers, sellers, and platforms alike. And without objection, the documents offered by Ms. Lofgren will be admitted into the record. For what purpose does Mr. Massey seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
I'd like to associate myself with the concerns expressed by Ms. Lofgren and Mr. Shabbat, and also with the hopes and objectives expressed by Mr. Issa and Mr. Johnson. Regrettably, I can't support this bill today. I say regrettably because there is a problem here. People are getting ripped off on online platforms. Patents and trademarks and copyrights are being violated every day on online platforms. And I believe that a strong intellectual property system is one that will encourage innovation and has over the last 250 years in this country. So we need to protect it. But I'm worried because of some of the loose language and because of the concerns expressed by Ms. Lofgren and Mr. Shabbat, which I won't reiterate all of them, that this will do more harm than good if we don't tighten up the language in this bill. For instance, I do believe it's going to put more of a burden on small online sellers, while at the same time, it may create a giant loophole for the big online sellers. One thing that's really odd about this bill, it tries to get to product liability, but not by addressing product liability law, but by addressing trademark law. and then trying to create this subsection of trademark law that really doesn't exist, which is product liability with respect to trademark law. So it uses this vague term, implicate health and safety. Well, doesn't everything implicate health and safety? Or does nothing, or does virtually nothing implicate health and safety? It's such a vague term, and it belongs in product liability law, not in trademark law. It's important to protect trademarks, but I don't think this is, by selecting this narrow portion of it, it's the way to go about it. Does this create a large loophole for large online platforms? For instance, I was made aware of one case where somebody bought a battery on Amazon. The battery blew up. The person was harmed, and they successfully sued Amazon because Amazon was complicit in this sale. By the way, if you handle these goods, if you're distributing them, if they go on your truck and you've advertised them and you make a profit on these goods that's commensurate with the sales price, then you do assume some liability. We don't need to create another set of laws for the internet because we have a set of laws that work just fine for many years. But what I'm concerned about in that lawsuit, for instance, if Amazon, for instance, and I don't mean to pick on Amazon, there are plenty of online sellers, but if an online seller keeps a data bank of IDs, false IDs, from these counterfeiters, does that provide them immunity from lawsuits such as the one that was undertaken and successfully litigated by the person who was harmed? Meanwhile, the small companies that don't have the wherewithal or the ability to spend the overhead to keep this database of false IDs, by the way, a lot of them are going to be false IDs and false credentials. If somebody can fake a product, if they can manufacture a fake product, then they're easily going to be able to create a fake piece of paper that claims where they are, or how to sue them, or what their credentials are. So it's not going to be a problem for the counterfeiters to counterfeit a piece of paper if they're counterfeiting a product. This came up, by the way, in the hearing. But is it the case that this bill creates an enormous loophole that we would never consider giving to, for instance, Walmart or a brick and mortar store for product liability? That's a concern of mine. We need to make sure that in the pursuit of protecting small inventors and online sellers, that we don't create the inverse problem where we just burden them with more paperwork while providing a large, giant loophole for the big companies. So for that reason, and for some of the loose language in here, regrettably, I cannot support this bill today. I appreciate Ranking Member Ice's willingness to work on this because there is a problem here, but I believe this bill is not the correct solution and it could cause more.
Would the gentleman yield?
I would yield to the Ranking Member.
I thank the gentleman, and I do look forward to working on the specifics of your concerns. We do want to get this right, and I appreciate what we talked about yesterday and your continued effort. So thank you, and I pledge to make sure we do address those concerns.
I thank the gentleman from California, and I'll yield back the balance of my time.
The gentleman yields back. For what purpose does Ms. Jackson Lee seek recognition? For what purpose does Ms. Jackson Lee seek recognition?
Mr. Chairman, I move to strike the last word.
The gentlelady is recognized.
There are issues like this that really draw upon deliberative discussions that members have now engaged in, and I applaud it. I applaud as well Chairman Nadler and Chairman Johnson for seeing a problem and working extensively to try and address it. I also appreciate Chairwoman Loughran for a commitment to continue to expand on her concerns and to work with the Judiciary Committee on those concerns. When you engage with the online industry, tech industry, you know that they're concerned in many instances is not to be bad neighbors, but it is to ensure the continued vitality and vibrance of that industry, which is an important aspect of America's economy. And I'm convinced on those issues that we need to listen and find common ground to continue to promote their ability to be the substantial economic engine that they are, but also to be able to find the new technologies that will make them the superior product and companies around the world. We know that they are not far away from the attempt by China to continuously bring them to a demise, to undercut the work that they do and the technology they have and the prominence of capital that they have access to. But as I look at the challenges of online sales, whether it is through small business or otherwise, small businesses can secure products that they are not aware of. I also look to the population that utilizes online sales, elderly, disabled, people of color, looking for the best deal that they can get. So I think the Shop Safe Act has tried to establish a protocol by establishing trademark liability for online marketplace platforms when a third party sells a counterfeit product that poses a risk to health or safety and that platform does not follow certain best practices. And so I think of the consumers when I think of this legislation and the attempt that it had to solve that problem. I would like to see a framework like this continue and go to the floor, but I'd also like to be able to not have any undercut of the productivity and the technology that these companies possess. I had an amendment that would clearly just restate what we're trying to obtain. And that included increasing vetting, transparency, screening, information sharing, and standardized enforcement measures that will decrease the health and safety risk to consumers inherent in illegitimate goods, economically strengthen small business owners, and give businesses the benefit of certainty for what actions must be taken to avoid liability. As we have agreed as members not to offer amendments, I do think that focus is the focus of the legislation, should be restated and reiterated and used as the premise of making sure this legislation can do that, at the same time be a boost to our economic engine and reflect on the challenges that companies have in the international marketplace. If we do that, if we are able to assure our consumers who are unprotected, online consumers are basically unprotected. If we can assume this posture that they will be protected, if they can be provided the most knowledge, if they cannot suffer products that will come to their door that will be injurious to them, that their money will not be taken in vain, and that small businesses will not be in a non-competitive or be disadvantaged in the online market, then I think we will accomplish what H.R. 5374 is attempting to do, and I hope we can accomplish it working with Ms. Loughran and others on their concerns as we move this legislation to the floor. With that, I yield back.
Lady yields back. For what purpose does Ms. Sparks seek recognition?
I'm going to strike the last word.
Lady is recognized.
Thank you, Mr. Chairman, and I appreciate your leadership and Congressman Isa's leadership on this issue. I think it's a very important discussion to have, and it's an important issue for a lot of Americans, but I would like to echo Red's role of the bill. I'm known for reading bills, and I want to echo a little bit what Ms. Lofgren said, Representative Macy and Representative Shabbat, that the definitions are broad and the definitions need to be tightened. And when I look at a lot of these rules and compliance, every time I have concerns that only companies like Amazon will be able to comply with all of this because they can hire very expensive CPAs, and I used to be involved with Fortune 500 in America and very expensive attorneys. So we need to make sure that we are not going to create an environment where the little guy will have even harder to be able to enter this markets and be able to participate in free enterprise trade. So I'm very open-minded, and I hope at the end I will be able to support this bill, but for the same concerns that my colleagues just expressed, I would not be able to support it at this time, but I look forward for this bill to become good legislation in the end. Thank you so much, and I yield back.
Gentlelady yields back. For what purpose is Mr. Liu seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman is recognized.
First of all, I'd like to thank you, Chairman Adler, for authoring this bill and all their co-authors and for identifying this important issue. Counterfeiting has been a significant problem even before the explosion of online retail. One of the first bills I got signed into law when I was in the California State Legislature actually changed the nuisance law in California to make it easier to take down folks who are selling counterfeit products. And I believe we need to do more to stop counterfeiting. At the same time, I do agree with some of their comments from Representatives Lofgren and Massey. I do think that this bill does need some work. However, I am going to vote yes and allow the legislative process to continue. I also do commend this bill for trying to harmonize the differential treatment that we sometimes see between brick and mortar stores and online places. I think this committee should adopt a principle that to the extent possible, we should harmonize those two, because we shouldn't have widely disparate standards for a brick and mortar store compared to an online platform. And so I just want to make a note also about the antitrust bills, which I made the same exact comment before. If we think there is a bad practice, then it should apply in terms of us trying to stop that practice, whether that practice is being engaged in by Amazon.com or Walmart.com or the Walmart brick and mortar store. What this bill seeks to do is to harmonize that and apply standards to online platforms to make it more similar to brick and mortar stores. I think as you all are still revising antitrust bills, you do that as well and make sure that if there's a bad practice in the antitrust bills that you want to ban at, let's say, Amazon.com, make sure you ban it for all brick and mortar stores as well. With that, I yield back.
Would the gentleman yield? Mr. Liu?
Yes, I'm happy to yield.
Thank you. I appreciate that. I want to just add a comment to what you've been saying, and I agree with you. And I agree with my colleagues that we have a serious problem with counterfeiting, and we need to address that problem. But I think when you talk about brick and mortar stores and online sales, we've got to also recognize that we have flea markets in this country, and we have lemonade stands at the side of the road in this country. And we have to recognize that we're not just talking about trying to harmonize the rules that apply to Amazon and a Walmart store, but we also have to try to harmonize the rules that apply in all areas. And it's the reason why I can't vote for this bill, because I don't think a one-size-fits-all is going to work. I look forward to working with my friend, Mr. Issa, to improve this bill, and I think it can be improved, and I look forward to supporting it, as Ms. Spartz and so many others have said. But I am very concerned about the language in this bill favoring a company like Amazon at the expense of so many other companies. So thank you for yielding, and I yield back to the gentleman from California.
Thank you, and I yield back.
The gentleman yields back. Are there any further speakers or amendments? If the question occurs on the amendment and the nature of a substitute. All in favor say aye. Opposed,
Aye.
nay. Opposed,
No.
nay.
No.
The ayes have it.
Mr. Chairman, I'd like a recorded vote.
That was just the ANS. The ayes have it. The question occurs on the amendment in nature of a substitute. A reporting quorum being present, the amendment is on the motion to report the bill H.R. 5374 as amended unfavorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
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 The ayes have it. The bill is ordered reported favorably.
Mr. Chairman, I would request a recorded vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson Lee. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Aye.
Mr. Deutsch votes aye. Ms. Bass. Mr. Jeffries. Mr. Jeffries votes aye. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Dimmings.
Aye.
Ms. Dimmings votes aye. Mr. Correa.
We are voting.
Okay.
So
Who
the
just
only
voted?
person-
Ms. Scanlon.
I'm not sure.
Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones.
Aye.
Mr. Jones votes aye. Ms. Ross.
Aye.
Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan. Mr. Jordan votes yes. Mr. Shabbat.
Aye.
Mr. Shabbat votes aye. Mr. Gomert. Mr. Gomert votes no. Mr. Issa. Mr. Issa votes aye. Mr. Buck. Mr. Buck votes no. Mr. Gates. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes aye. Mr. Biggs. Mr. McClintock. Mr. Stubbe.
Yes.
Mr. Stubbe votes yes. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey.
No.
Mr. Massey votes no. Mr. Roy. Mr. Bishop. Mr. Bishop votes yes. Ms. Fishbach.
No.
Ms. Fishbach votes no. Ms. Sparts.
No.
Ms. Sparts votes no. Mr. Fitzgerald. Mr. Benz. Mr. Benz votes yes. Mr. Owens.
Mr. Chairman, how is Swalwell reported?
Mr. Swalwell, you are not recorded.
Aye.
Mr. Swalwell votes aye.
Mr. Chairman.
Chairman, how's Biggs recorded?
Chairman, how is Jackson Lee recorded?
Ms. Jackson Lee, you are not recorded.
I vote aye.
Ms. Jackson Lee votes aye.
How's Bass recorded?
Ms. Bass, you are not recorded.
Bass votes aye.
Ms. Bass
As
votes
Biggs
aye.
recorded.
Mr. Biggs, you are not recorded.
No.
Mr. Biggs votes no.
How is Scanlon recorded?
Ms. Scanlon, you are not recorded.
Scanlon votes aye.
Ms. Scanlon votes aye.
Is Correa recorded?
Mr. Correa, you are not recorded.
Correa votes aye.
Mr. Correa votes aye.
Are there any other members who wish to be recorded who haven't been recorded? The clerk will announce the result.
Mr. Chairman, there are 30 ayes and 8 noes.
The bill is passed. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. We are now going to consider 5 private immigration bills en bloc pursuant to a notice I call up H.R. 187 for the relief of Victoria Galindo Lopez, H.R. 680 for the relief of Arpita Kerdukar, Girish Kerdukar, and Vandana Kerdukar. H.R. 681 for the relief of Rebecca Trimble, H.R. 739 for the relief of Median of El Mustra, and H.R. 785 for the relief of Maria Isabel Bueso Barrera, Alberto Barreso Mendoza, Carla Maria Barrera del Buso, and Ana Lucia Bueso Barrera for purposes of markup. Without objection, I move that the committee report the bill en bloc favorably to the House. The clerk will report the bills.
H.R. 187 for the relief of Victoria Galindo Lopez.
Without objection, the bills are considered as read and open for amendment at any point. The text of the amendment, in the nature of a substitute to H.R. 681, circulated to members on Monday, is agreed to. I will begin by recognizing myself for an opening statement. As my colleagues are well aware, this committee considers private bills under the longstanding process and bipartisan agreement developed in 1980 in the aftermath of the FBI sting operation known as ABSCAM. Under carefully crafted procedural rules, we only consider compelling cases in which removal of the beneficiary would result in extreme hardship or injustice. In making this assessment, precedent in the modern congressional era is an important consideration. In the modern era, Congress has passed several private bills where the extreme hardship that would result from the beneficiary's removal centers around medical issues or an international adoption that was not finalized. In 4 of these cases, a beneficiary or the U.S. citizen child of the beneficiary suffers from 1 or more serious medical conditions that would undoubtedly be exacerbated if the beneficiary were removed. In the 5th case, the beneficiary was brought to the United States by her U.S. citizen parents when she was just a few days old and only discovered that her adoption had not been finalized in accordance with the law and that she was not a U.S. citizen when she was an adult. The facts of each of these cases are compelling and uncontroverted. There is bipartisan agreement that these cases meet committee precedents on private bills. In addition, the Subcommittee on Immigration and Citizenship requested and received reports from the Department of Homeland Security on each of the named beneficiaries. None of the reports revealed information that would prevent us from proceeding with today's markup. I would like to commend the work of my friends and colleagues, Representatives Julia Brownlee, Ann Custer, Don Young, Rashida Tlaib, and Mark Desaulnier for their enduring support for these deserving families and for introducing these bills on their behalf. I urge my colleagues to vote to report these bills en bloc favorably to the House. I now recognize the distinguished ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I don't oppose the 5 private bills we're considering today because they fall under existing committee precedent for private immigration bills. But I think it is important to point out the current state of our border and to recognize that the Biden administration has utterly failed, totally failed to enforce our immigration laws. President Trump secured our border and enforced our laws. The Biden administration has reversed President Trump's policies, and now we have an unprecedented security and humanitarian crisis on the border. Republicans have repeatedly asked Chairman Nadler and the Democrats to have hearings on the Biden border crisis. Chairman Nadler has ignored these requests. In fact, I asked Mr. Mayorkas, Secretary Mayorkas, yesterday, will you volunteer to come talk to the chairman about coming and testify? I don't know in my time on the Judiciary Committee we've ever went almost 10 months now without having the head of Homeland Security in front of the committee. Democrats have absolutely no interest in discussing the border unless it is to demonize the brave men and women of Border Patrol with lies about cruelty. Democrats have absolutely no interest in examining our immigration enforcement unless it is to give amnesty to at least 8 million illegal aliens. Mr. Chairman, whether you want to recognize it or not, there is a crisis on the border caused by President Biden's radical far-left policies. I hope you will finally accept Republican calls to examine this crisis, and we will have Secretary Mayorkas in front of the committee soon. In the meantime, 5 private immigrations we are considering today grant a path to a green card for each of the named beneficiaries in the bills. We are moving these bills pursuant to our longstanding bipartisan private bill agreement. The agreement requires that the circumstances on which the alien is based, the need for a private bill are the same or substantially similar to the circumstances in a private bill enacted at some point since the 97th Congress. Adherence to precedent ensures that bills are considered solely on their merits and not because of the influence of particular members who've introduced them or the parties of the members who have introduced them. Almost any conceivable immigration scenario has been played out over the decades with the admission of many millions of permanent residents and non-immigrants and the entry of millions of illegal immigrants. There is no precedent for a particular private bill. This means that in all likelihood, Congress has been presented with the scenario in the past and decided that enactment of a private bill was not warranted. The 5 bills today fall under the precedent, providing a green card to an individual based on his or her own health needs, the health needs of a family member for whom he or she is the caretaker, or in the case of an international adoptee whose parents did not file the paperwork necessary to ensure U.S. citizenship for the adopted child. I yield back the balance of our time.
Gentleman yields back. A report.
Mr. Chairman,
For what purposes does Ms. Lofgren seek
I
recognition?
just strike the last word.
Gentlelady is recognized.
I will not repeat the comments that you made about each of these cases. They are accurate. I just want to report that, as is our practice in the Immigration Subcommittee, we did request a report from the department on a bipartisan basis. We received those reports, and I have reviewed them. There is nothing disclosed in those reports from the department that would prevent us from advancing these bills. And in fact, as has been mentioned, each of these bills fits firmly within the precedents that we have adopted and applied, no matter which party was in the majority over these many years. I would like to note, however, that these cases plainly illustrate deficiencies in our current immigration laws and the need for reform. I believe as legislators, we can and should do better. We need to reform our immigration laws so that our societal values can be advanced without the necessity of enacting an individual law for a person who is in need of relief. So I approve these bills. I look forward to advancing them, but I hope also that we will have an opportunity to reform our much-dated immigration laws. And with that, Mr. Chairman, I yield back.
Gentlelady yields back.
Mr. Chairman.
For what purposes Mr. Tiffany seek recognition?
Mr. Chairman, move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. So I'm really appreciative that this committee is using the proper process to, in regards to immigration. It is refreshing, actually, to see that this committee is doing this in the appropriate manner, because the Biden administration clearly is not doing it in the correct way. I've been to Fort McCoy in Wisconsin, where we have about 13,000 Afghan evacuees that have come in there. We were told 6 weeks ago, there was going to be a thorough vetting process, including the SIV process, the Special Immigrant Visa process. What did we find out when we went to Fort McCoy? None of them. None of them went through the SIV process. So think about it, the terrorism hotbed of the world, Al-Qaeda, ISIS, the Taliban, all in Afghanistan, and we're not doing a thorough vetting process. And in spite of what the administration is saying, they're not doing a thorough vetting process. Everyone should be in a safe third country before they come here to the United States and go through the special immigrant visa process, and that is not being followed here. And what do we get as a result of it? Nobody's going through the SIV process. We found that out at Fort McCoy. 600 people in quarantine. That was about a week and a half ago with diseases like measles, COVID, tuberculosis. And so clearly not being vetted for what may be terror backgrounds, but not even being vetted for the health and safety of those people that are coming into our country. And then, of course, we have violent crime. We have people that are up on charges now, evacuees for beating their wives, for raping young boys, for beating a military member of ours out in Fort Bliss, a group of evacuees beating up on one of our finest that serve our military. That's the kind of stuff that's happening as a result of a broken immigration process, of an administration that insists on open borders. And there is no other way to put it at this point. All you got to do is look at the southern border. And it's not just Texas. It is Arizona, New Mexico, and it's California. It is broken, and it is simply an open borders process at this point. And the American people are alarmed by it. So I want to thank the chairman of the committee for and the authors of this for going through the appropriate process, because the Biden administration is not, and it is doing great harm to our country, and it has the real, could have the real effect of importing terrorism into our country, and that is the worst thing that could possibly happen. I yield back. I'll yield to the gentleman from Ohio.
I thank the gentleman for yielding. I think this is so important. The overall context now is this is what the American people see. 6 months, month after month, a higher number of illegal encounters on our southern border than the previous month, all the way up to 212,000 in July. Records. Each month was a record. It just kept getting worse. 64,000 Afghans brought to the country, 15,000 Haitian migrants we just saw over the last 3 weeks play out under the Del Rio Bridge, and now most of them are somewhere in America. When we talked to Mr. Mayorkas, he couldn't tell us exactly where. And another 15 to 60,000 coming in a caravan to the border. And yesterday, when we had a meeting with Mr. Mayorkas and Secretary Mayorkas and Secretary Blinken about the refugee issue, they told us that Border Patrol agents will be fired if they don't get the vaccine, but when illegal migrants come across the border, they're given a choice whether to take the vaccine. That's the state of affairs. That's what they told us yesterday. That is totally correct. I heard him say it. And yesterday, what did we find out from Secretary Mayorkas and Secretary Blinken? They're going to double the refugee number. So that's the overall context. 6 months, record illegal encounters on our border, 64,000 Afghans brought to the border, 15,000 Haitians somewhere in our country, Haitian immigrants in our country. We don't know where. More coming, thousands more coming. And we doubled the refugee number from 62,500 to 125,000. That's what, and all that, and we can't get Secretary Mayorkas to come sit at that table and answer questions and concerns that our constituents have in the districts we all get the privilege of representing. That is the state of affairs. So yeah, why we support these 5 private bills, the overall picture, what the American people see, that's what we need Secretary Mayorkas. I yield back to the gentleman.
In a couple seconds that are left, the parole authority is absolutely being abused here, circumventing the SIV process with the evacuees from Afghanistan. Almost all of them are coming in on parole, which is not what the parole law was set in place to do. I yield back.
Mr. Chairman. Mr. Chairman.
Gentleman yields back. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, I move to strike the last word.
The gentleman is recognized.
And I'll yield to the gentlelady from California.
I thank the gentleman for yielding. Chairman Nadler and I were also at the refugee consultation meeting with Secretary Blinken and Secretary Mayorkas, and it's not correct that the vaccination information that apparently the ranking member thought he heard, that was not relayed to us. I need to correct the record on that. I would like to note also that when the Afghan government collapsed, there were many thousands of applicants for the special immigrant visa that the prior administration had declined to adjudicate because they shut down the USCIS. As a matter of fact, a year ago, August, had proposed to lay off 3/4 of the employees of USCIS, and we put together, I'm sure you recall, Mr. Jordan, a bipartisan deal working with Mr. Fortenberry to try and prevent the layoff of most of the employees of USCIS. However, they did a hiring freeze and they simply stopped processing these applications. There's some indication that that was at the direction of Mr. Stephen Miller in the White House, who was opposed to immigration, both irregular and legal. So the fact that people had not yet been approved for their special immigrant visa is a legacy issue from the prior administration. The use of humanitarian parole to protect individuals deserving of protection is an issue of long standing in immigration law. And I would argue, and I think the American people agree, that if we had someone who protected our troops, a translator, someone who was a valued employee in our embassy, someone who was collaborated with the American government and was at risk from the Taliban, that needed to be dealt with successfully. And so the use of humanitarian parole was employed. I will say further that additional screening is going on for those who have been paroled in. And unfortunately, not every person paroled in was perfect. The incidents reported on of assault by a parolee has been dealt with very swiftly. We were told by the Secretary of Homeland Security that those individuals are in removal proceedings or being subject to criminal prosecution, and they will not be permitted to stay in the United States, which is as it should be. So I think there's a lot of rhetoric that unfortunately will lead the listener to an incorrect conclusion. And I think it's important that we understand our obligations to our allies, to those in Afghanistan who stood by our soldiers. I was very proud that we had a bipartisan effort here in the House of Representatives, primarily led by members of Congress of both parties who are veterans, who stood up and said, we need to stand by those who helped our troops. And that is exactly what the president did when he used the parole authority to evacuate people who stood by our soldiers. So I thank the gentleman for yielding so I could make these corrections, and I return the time to Mr. Cicilline.
And Mr. Chairman, I yield back.
Mr. Chairman.
Mr. Chairman. Mr. Chairman.
The gentleman yields back. For what purpose does Mr. Shabbat seek recognition?
Move strike last word, Mr. Chairman.
The gentleman is recognized.
Thank you, Mr. Chairman. I know a number of our members have already spoken up on this, but I would like to add my voice to this debate. I do support the private immigration bills that are being considered here today, and I commend the chair for bringing these up. I think they're all worthy of us passing. However, this committee continues to ignore one of the most critical issues that we have facing us here in this country, and that's the fact that our southern border almost doesn't exist anymore. Now, the guy in charge of this, Mayorkas, recently said that the border's closed. And so we're supposed to look the other way and assume that we're being told the truth by this administration, but in fact, we're not being told the truth. because our own lying eyes show that people are streaming across that border in the tens of thousands and the hundreds of thousands. And now, yes, over 1 million people entering this country at the southern border, not doing it the right way, like so many people have come into this country over the years, but breaking in line in front of the people who are trying to do it the right way. They're cutting in line. When you look at what's happened, how this administration, the Biden administration, and I would say aided and abetted by our Democratic colleagues, both in the House and the Senate, because they won't speak up. They won't pass any legislation to stop this illegal behavior. They have reversed completely what the previous administration did that actually got the border under control, finally, actually building a wall. Well, Biden stopped that immediately. And so now we've got that material that taxpayers paid for, which is sitting out there rusting, rather than keeping illegal out of the country as it was intended to do. This administration, the Biden administration, reversed the stay in Mexico policy, which actually worked. We had agreements with other countries. We're supposed to be working with other countries on problems that we face, and that's what the previous administration did. But the Biden administration reversed all that. So we don't work with them anymore. They don't stop the people at the southern border of Mexico from coming in. So they go there, they travel right through the country, then they just enter. They walk across the dam. They walk across or swim across rivers. They get into this country. They live under bridges. I mean, it's unbelievable what's happening. So they reversed the stay in Mexico policy. We now have catch and release again. So we catch people, we just release them again. We put them on a bus, we put them on a plane and fly them all over the country. And we don't tell the people in that district, in those congressional districts, who's coming. We don't tell the members of Congress who's coming. And this is happening on an ongoing basis all over the country. Unfortunately, a significant percentage of the people, it's been estimated about 20% of the people coming in at our southern border now illegally have COVID. And some are tested, some are not, and they just head out into the population. And so clearly some of the spread in COVID right now is coming from that source. Unfortunately, some are working with the drug gangs, the drug cartels, and they're bringing fentanyl into the United States. And it's killing tens of thousands of American citizens. And this huge increase in humanity that's come across the border, who's paying for all these folks now? The American taxpayer are. The American taxpayers are paying for food, housing, schools, healthcare, the criminal justice system. All this is being paid for by the American taxpayer. This makes absolutely no sense, but this administration, the Biden administration, and my Democratic colleagues here in the House and on this committee and over on the other side in the Senate, they're ignoring this problem completely. We don't even want to talk about it. And now in this new boondoggle bill, this $3.5 trillion bill that they're trying to cram through and down the throats of the American people this week, they put in there something that they don't want people to know about. They're not really talking about it much, but free college for people here illegally now. American young people are struggling to pay for their college, but we're going to give free college to people that have come into this country illegally. It makes absolutely no sense, but that's what my colleagues on the other side of the aisle are doing. That's what they're for. So yes, let's support these these private bills today, but let's also talk about what's happening in this country. In our southern border, it's an absolute crisis, and it's all on the Biden administration. And I yield back.
The gentleman yields back. For what purposes Mr. Issa seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I'll be brief. I totally support the structure and the precedent that causes these bills to be before us today, and we'll be voting for them. I want to point out, though, that it is likely that because of the events in Afghanistan and because of those individuals, including a number from my home district, who find their loved ones, their immediate family, stranded in Afghanistan, that similar legislation outside our historic precedent should be necessary. And I would ask the chairman to form a working group so that we can look at how we would grant appropriate visas / immigration status to immediate family members of those in the United States or trapped there, whose family members are there in a country that we no longer have an embassy at, and for which departing the country requires great peril and cannot be done without an immigration status granted by the United States or some other country. I would ask that because we are a committee of primary jurisdiction for that question of their right to be in the United States, that the chairman work together to find a way within our rules to produce a valid bill.
Mr. Issa, we will certainly work to find a way, but I don't think we need a working group. I think the immigration subcommittee can do
That would be the working group I was thinking of.
Well, very good. We're in agreement.
Thank you, and I yield the remainder of my time to the ranking member.
I thank the gentleman for yielding. I wanted to go back where the chair of the Immigration Subcommittee had some of her comments earlier and wanted to, I think, put it in plain language. 64,000 Afghans have been brought to the United States. We learned yesterday from Secretary Mayorkas and Secretary Blinken, 7% of that number are actually U.S. citizens, 6% are lawful permanent residents, 3% have a special immigrant visa. So 16%. The other 84% don't fall into any of those categories. So over 50,000 don't fall into those categories. And here's what happens for most of them. Most of them don't have an ID. Most of them, when you enter their name and put it in the database and they query the name,
Would
nothing
the gentleman
comes up.
yield?
No, I'm responding to all the things that you said that weren't accurate. But by the way, here's what Secretary Mayorkas said yesterday too. He said they're offered, going to the Haitian issue in our southern border, people coming across, they're offered a vaccine. If that's not choice, I don't know what is. When you're offered something, you can say yes or no. That's a choice. That is what he said yesterday. So to say that that is not accurate is simply not accurate. 64,000 brought here. Over 50,000 don't fall into those three categories. Many of them, no ID. Many of them, when you query them on the database, there's nothing that comes up. So they're given an interview and they're brought into the country. That is what happens. Now, maybe the Democrats think that's all fine, but I know a lot of the folks I represent would like a little more vetting, a little more focus on who's coming into our country. That is our concern. I think that's the concern of the American people. And then you couple that with everything else the American people have witnessed over the 9 months of this administration on our southern border with Haitian migrants, and all they've seen. That is what we need a real discussion on. More than just a working group, we actually need hearings where we bring in Secretary Mayorkas to answer our questions. And the idea that he won't come and you won't invite him, I just don't get it. I do not get it. That's what we're asking for. That's what the American people see. I yield back to the gentleman from California.
I yield the remainder of my time to the gentlelady from California.
I thank you, Mr. Issa. I think there is some confusion here. At the refugee consultation, the question was raised, what happens with someone who doesn't have ID? And that can happen. It was never reported that the people who were paroled in didn't have ID. There is a process where you take biometrics, you run them against all the databases, and if it comes up clean, then you go into extensive interrogation to find out about the person. So to say that that's all 64, the percentage of people that did not enter as U.S. citizens or LPRs or SIV holders are all in that category. So that was not the report that we got. And I just think, I would like to adopt these bills, these private bills. The lives of all these people are hanging in the balance. We are having this broader debate, but I think it's a disservice to the members of Congress who are on both sides of the aisle to, sort of sidetrack these private bills. If we could adopt them, I think that would be appropriate. And I thank Mr. Issa for yielding, and I yield back.
Gentleman, yield again.
The gentleman's time has expired. I recognize myself. The people who were in those, who were airlifted out of Afghanistan were all people who had to flee Afghanistan because they worked with American forces, because they helped the United States, and thus are at risk from the Taliban had they stayed there. The vetting the vetting will presumably show that. They will be vetted, but the fact is, we know that the people who had to flee were the people who worked with American forces, and they are the people who deserve immigration status.
Will the chairman yield?
I will yield.
Sir, would that include, I mean, these are what I understood to be translators for the United States, but what I'm understanding from reports is that many of them don't understand English. Are they translators for the United States?
Would the gentleman yield?
I'll yield to Mrs.
There are, oh, Ms. Jackson Lee. There are a variety of individuals who worked with, some were translators, some were employees of the embassy, some were reporters. They were all allied with the United States, and they are going to be vetted primarily for those who don't have ID, which was by no means indicated a substantial number, will be vetted through interrogation, and frankly, part of that will be making sure that the Americans they worked with are also reached out to so that we can sustain who these people are. I do think it's a mistake, and there was a discussion and Republican members would not agree, that people in the parole status, there's really no route from parole to any other status except asylum, and that's going to be another vetting, because if you're not eligible for asylum, then you're also going to have to leave the United States. So there are multiple layers of sorting and investigations of these individuals, but the basis for this is not just translators, although we include translators, but also others who were aligned with the United States and allied with the United States, who helped the United States, and who were at risk when the Afghan government failed. And I would yield back to the gentlelady. Thank you.
And
Mr. Nadler's
I would just add, and again, remember, the Afghans who came to the United States who do not speak English can tell us who they work with among American forces, and those people can verify their identity and the fact that they work with them. If they can't, then that's a different question. I'll yield back. For what purpose does Mr. Biggs seek recognition?
Move to strike the last word, Mr. Chairman.
The gentleman is recognized.
Thank you, Mr. Chairman. We started off talking about the private bills, but this has evolved and moved forward. And I just want to point out a couple of things that I find are rather interesting. Having been down to Del Rio, having been down to the Arizona border multiple times, having been from McAllen to San Diego this year alone, multiple times in most sectors. The only sector I haven't hit this year is Big Bend. I got to tell you, the numbers that I heard was that over 8 days, 26,000 Haitian migrants came across in Del Rio. Literally hundreds of buses per day were dropping folks off in Ciudad Acuña, which is literally right across the border and a short walk across the Rio Grande River. What happened to those 26,000? We know because it's totally emptied out now, except for the normal process of the several hundreds a day that had come across into Del Rio. Well, what happened is 2,000 or so were sent back to Haiti, even though most of them had come from Central and South America, where they had been living with legal status for a good number of years. The rest of those folks have already either been released into the interior of the country, or they're waiting in processing centers in Tucson, El Paso, the Rio Grande Valley, or Houston. That's where those folks are. They're going to be released as well, because what's happening is DHS Secretary Mayorkas is using parole status, which was not ever intended to be a mass migration release into the country. Never was supposed to be there. So that becomes a huge problem for us. All the CBP agents are now being told that you have to be vaccinated. All of those people that flowed through Del Rio were not tested for COVID, nor were they mandated to have vaccines. They were sent to transition centers or processing centers where they were released into the interior very swiftly. During that 8 days that Del Rio was being overrun under the bridge there, max about 15,000 or so at any one time, 224 miles of border were vacated and not patrolled. They couldn't be because our Border Patrol men and women were overburdened at that bridge. All of them were there from that Del Rio sector, as were people coming in from other sectors to help out, as were the Department of Public Safety from Texas. And what did we get out of that? We got a false story about the Horse Patrol. I have seen multiple videos from people that were there from various angles.
The gentleman
all
yield?
angles. No, I'm not going to yield. I am not going to yield. What happened is a travesty to blame these Border Patrol agents now saying, look, we're going to come after Border Patrol agents for patrolling the border. They did not act improperly in any way. And as the investigation unwinds, that's what we will find out. What you saw, though, is everybody getting notice to reappear, NTRs. And what's going to happen is these people are not going to come. That's what's going to happen because they've been paroled. And we are facing a real situation there that remains a crisis. Now, the other aspect of this is that the Del Rio port of entry had to be closed. Until that was closed, there was no leverage point on the Mexican government to help turn away the busloads that were being brought in every day. Once that was closed, there was now impetus and strength. So we had a MASH hospital set up down there, multiple units for a MASH hospital set up, volunteers coming from doctors and other medical care professionals coming from Minnesota down, and they served there. 11 babies born in that Del Rio area. One of them actually in the encampment itself, the other 10 being transported to the hospital. All of that took place, and we can't get anyone from the administration, from President Biden to his spokesperson, to Secretary Mayorkas to even say there's a problem on the border. We can't even get the gentlewoman from California to say that these folks are illegally in the country. Instead, they are apparently irregular entrants. This is absolutely incredible. We've got to get a handle on this border crisis, and I'll yield to the gentleman from Ohio, the ranking member, Mr. Jordan.
I'm fine, thank you. I yield back.
I yield back.
The gentleman yields back. For what purposes, gentlelady from Texas seek recognition?
Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you. Let me recharacterize.
Gentlelady yield to me.
I will yield.
Thank you. I just want to note that we have a very long agenda ahead of us today, on which we will have ample opportunity to debate all these different issues. It seems we're all agreed on these private bills. So why don't we take a vote now on the private bills, go on to the next bill, we can debate to our heart's content all the other subjects.
Mr. Chairman, this is exactly why we need Secretary Mayorkas here to have this debate. But if you're not going to bring him, we got to have it sometime.
You can discuss that after the private bills. I just think in terms of the the length of our hearing today, we should vote for these private bills and then debate anything anybody wants. I yield back to Ms. Jackson-Lee.
I thank you, Chairman. the goodness that I want to express is thank goodness for the goodness of the Biden administration, combined with an effective law enforcement structure for securing our border. Thank goodness for the Border Patrol agents who have consistently worked, many of whom I have known for years and worked with as a resident of Houston and an active member of Judiciary and Homeland Security, having led border security committees, transportation security committees, been to the border any number of times. Let me pronounce to my friends that the border is both sovereign and secure. It is obviously subjected to biased and unfair narratives for political purposes. So I do want to acknowledge the private bills very quickly. Victoria's daughter suffered sexual assault. They will be left with no parent. We have someone who's been paralyzed in Arpita who needs relief. We have someone who has been granted conditional permanent residence, but the marital status changed in terms of medium. And then, of course, the relief of Maria, where her family came and she needs extreme medical care. That's what we should be talking about in passing the bills. But to my friends, I was at the border as well, many times that I've been at the border. And I'm offended by the insensitivity about the plight of Haitian migrants who are fleeing for their life, for a unstable and desperate government where individuals were fleeing from having their wife raped in her bed or a son murdered or an inability to escape violence, and then to come to South and Central America where they were having their work permits removed and basically being stateless. That is the definition. You have no place to go. We are a better country than that. Some over 300 million persons, jobs going unattended to. So the process should be, as we did, myself and Senator Kerry at that time, where we pumped up and provided more resources for the border. I am not hesitant to provide those resources. I've done it before. And I am not hesitant, as I did over the weekend, to walk and engage to find out what is going on with the Border Patrol. I know about the 11 babies. I know about the Venezuelans and the Cubans who were there in the processing center as I look. But what they asked for is that you've got to stand up infrastructure there along that border for them to do their job, and then for the ultimate job to be done by the court system. Where are we providing more judges and courts to deal with this process? Have we knocked over the Statue of Liberty in our harbor? Is anyone here going to deny that they came from somewhere else through their heritage? You weren't here. The indigenous people were here. I came as a slave in terms of my ancestors. I'm a descendant thereof. For all of the people that'll be on social media, no, I was not a slave, but I'm a descendant of it. So we all came from somewhere. We need to stop this untenable narrative for a country that has been built on immigrants and laws. And what I would give to that border, the state that I live in, is the resources they need, not the phony resources of state intervention that has no business taking state of Texas funds from children in schools and grandstanding at the border. We need to provide our federal officials with the resources they need, the stand-up system, medical system, if that surge comes. Because I can assure you, no one person, no 10 Border Patrol agents is going to be able to stop this if this comes. But we can work together with the Foreign Affairs Committee, with the State Department, to deal with those countries and find a way for individuals not to have to flee. And finally, let me say, walk a mile in my shoes before you want to consider it irrelevant as to what happened with those horses. I'm not maligning personally the individuals.
Time has expired.
I'm not maligning personally, Mr. Chairman, the individuals, but it was a horrible sight for those of us who have a history of looking at that in the history of the United States of America. And we will always talk about that because we were hunted down as individuals who had our slave ancestors were hunted down. Understand, walk a mile in our shoes. Let's vote on these bills. I yield back.
For what purpose does Mr. Bishop seek recognition?
Move to strike the last word.
Gentleman is recognized.
I thank the gentleman, and I yield to the gentleman from Wisconsin, Mr. Tiffany.
Thank you to the gentleman from North Carolina. So I do want to address what the Immigration Subcommittee Chair was saying when she said that she was going to debunk the things that she had heard previously. But first, many of the Haitians that are coming across the southern border, I saw in Panama. I went to Panama the end of May, and I saw where they were coming from. They were coming from South America. Now, maybe some came from Haiti. That's very possible. But what we were hearing in Panama, and the Panamanian government was very alarmed by it, is you had all these people that were coming, Haitians who had resettled into Chile or Brazil. The green light was turned on by the Biden administration. If you want to talk about the humanitarian crisis at the southern border, it is squarely at the shoes of the Biden administration because they stopped all the things that were getting control of our border. There's no other way to put it. So if you're concerned about people being in destitute circumstances down on the southern border, it's because of the Biden administration on January 20th. Now, I want to go back. The gentlelady from California has fallen into the trap that so many people have. I don't know if it's willingly or not. But it's talking about the Afghanistan issue in a binary choice. You're either for bringing Afghans to the United States or you're not. That is not the case. There is a much better way to do it, and I have talked about it consistently over the last 6 weeks. And it was to have people go to a safe third country, like Qatar, and make sure they have their vetting process completed there via a special immigrant visa. We have the way and the means to be able to do that. The State Department said when they were evacuating people out of Afghanistan, we will sort out the immigration stuff later. Quote from the State Department of the Biden administration, we will sort it out later. And so this whole notion that people are going to be fully vetted, let me read a quote that I received from personnel from the Department of Homeland Security down at Fort McCoy. We can't vet against what we don't know. I am confident that we are vetting against all of the information we know and have. So in other words, what they have, but it's a matter of what they don't have. There are many, many Afghans that have no documents. Some of them never got them. You don't go down to the Kabul DMV and just pull stuff up. That's not the way it works in Afghanistan. Some of them may have thrown away their IDs. Some of them were instructed to do that. This should have been done in a safe third country and brought those people in who actually helped us, because I do agree that some people are worthy of coming into our country, but that is not how the process was done with the Biden administration. And this whole notion that there's intensive interrogation and stuff like that, once people are in this country, they are in this country. They are not being fully vetted. This continues. What Robert Gates said in his book, who served both the Obama administration and the Bush administration. Joe Biden, President Biden, I will be respectful, President Biden has never gotten a foreign policy decision correct in his 45 years serving the American people. And Afghanistan is another example of the incredible failure that is going to come back and haunt the people of this country. I yield back to the gentleman from North Carolina.
I thank the gentleman from Wisconsin, and I think it worth noting, I have heard Secretary Mayorkas before the Department of Homeland Security, and he does need to come here, in my view. But he maintains a posture similar to what we've heard expressed today. There's no problem on the border. Everything's fine on the border. The border is sovereign and secure. The border security is effective. That's insane. It reminds me of Baghdad Bob. Remember the Minister of Information from Iraq? They are not within 100 miles of Baghdad. The Americans have fled. And it became a comedy routine, but there's nothing funny about this. If you listen to Secretary Mayorkas, and I assume he'd repeat himself if he were here, he repeats over and over again that they have a plan, and they're executing their plan every day. Now that is true. They are executing their plan.
Gentleman's time has expired. For what purpose does Mr. Gohmert seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you. And I do appreciate my friend from California's effort on these special bills. Worked with her before and appreciate her help. But this is, we're looking at splinters here when we've got big boards in our eyes. Yes, Mayorkas has said the border is secure, the border is closed. He said that a number of times, but he's also on tape telling the Border Patrol, if our borders are the first line of defense, we're going to lose, and this is unsustainable. We can't continue like this. Our people in the field can't continue, and our system isn't built for it. The question is, which time is he lying? Well, having spent time on the border, although no thanks to the Biden administration, I have trouble getting to the border because they're hiding what's going on from some of us. But I've spent many nights, all nights on the border, and I continue to hear from Border Patrolmen who are telling us what's going on. Yes, we have a lot of people, tragically, they don't have any IDs. It's difficult to get them properly vetted. It may have something to do with many of them disposing of their IDs. I've seen one person have dozens and dozens of IDs just picked up on the U.S. side because they've been told, okay, you're here, get rid of the IDs. It'll be easier to keep you in the country if you don't have any IDs. IDs from all over. And yes, our heart goes out to people struggling from Haiti, but I can't applaud the sensitivity of President Biden or his administration when I've seen these Haitians that were shipped back to Haiti to the place they didn't come from. They came from Haiti, they came to Central America, they came to South America seeking a better way of life. And they were doing okay, but then they heard President Biden's gonna open the border, throw the gates wide open, come on. And so they made the trip up there. It'd still be nice to know who's paying for all of that. Who's paying to ship tens of thousands of people from Central and South America to our border to get them into our country? We know the drug cartels make money off of it. We know that they use them to occupy the time of our Border Patrol so they can bring in drugs or what they call high-value assets into other areas where there's no one patrolling. The drug cartels control all of that, and it leaves us so vulnerable. And as far as the sensitivity of the State Department and Homeland Security, we still have American citizens in Afghanistan. Oh yeah, they got thousands of people over here from Afghanistan, and many of them conveniently did not have any identification. And since this administration allowed the Taliban to take over all of the government information, they're not going to provide us information on who's Taliban, who's going to be part of the next 9/11, who's going to use some of those $85 billion this administration left to people who want to destroy and have said they want to destroy the United States. But I'm also aware that when you had groups like the Nazarene Fund that had people on an airplane with all of their IDs, their passports, everything, and they're at a remote landing strip that the Taliban is not aware is being used, the State Department got all of their personal information and then provided it to the enemy, who then got to that airstrip, took those people off the plane, and we're not sure what happened to all of those. It almost sounds like people in the State Department are from the Alger Hiss type of State Department employees doing more to help our enemies than they are to help Americans. So I appreciate the private bills, but there are Americans suffering because we're not doing our job here. I yield back.
For what purpose does Mr. Fitzgerald seek recognition?
Thank you, Mr. Chairman. I just wanted to kind of go back and talk a little bit about what my experience was when I first heard that there were going to be Afghani refugees coming into Wisconsin and being located at Fort McCoy. And Mr. Tiffany and I took our own visit along with the Republican members of the delegation up to Fort McCoy. And I got to be honest with you, I've been to Fort McCoy hundreds of times. I was in the Army Reserves for 27 years. Fort McCoy kind of becomes a home away from home for any member of the Guard or Reserve in the state of Wisconsin. And I kept thinking to myself, I know those facilities, I know the base, I know what's available, what isn't available, and I thought to myself, where are they going to put these people? Where are they going to put them? And at that time, I think they were up to 3 Army bases. They're now at 6 Army bases, if I have that correct. But I was optimistic. I was kind of like, okay, you know, maybe these old World War II barracks and, you know, they made some improvements to the PX and the commissary, and maybe they would be able to take this on. And when we showed up for our visit, and there's a 2-star that greeted us, and State Department official, as well as immigration, everyone was very cordial about it. I tried to keep an open mind. I tried to think, okay, you know, maybe this is going to work. And then we simply asked for a briefing on who were these individuals, what was their profile, how much information did they have at that point. And I got to be honest with you, after about 20 minutes of this briefing, it was disturbing because you could see that there was very little information on these individuals. They did not even make the case that they were vetting. A 2-star general at that time said, listen, this is a reception station. We're not here to vet anybody. We're here to make sure that anyone and everyone that's here, first of all, gets housing, and then they get 3 meals a day. So we started to probe a little bit more. We asked about, what about medical? Do we know anything about their medical history? No, nothing. Do we know where they came from or what the contact was with the American military when they were in Afghanistan? No, no profile. Do you have any folder? Do you have any paperwork on these individuals? Only what they provided to us the day they showed up. I mean, at that time, there were 2,300 refugees, 2,300. I said to the 2-star, knowing the full capabilities of what Fort McCoy could provide, I said, what do you think the max capacity, the absolute maximum amount of refugees that Fort McCoy could handle and be able to do a good job? Oh, by the way, winter's right around the corner. And he said 10,000, 10,000. There's in excess of 13,000 refugees there right now. And I have not seen it, but I know they've started to erect temporary tents to try and house some of these people. I'm just telling you, this is a mess. I am not surprised by the incidents. I asked about criminal activity. I said, who's going to control that? There was a lieutenant colonel who had just showed up on the scene, had just been activated, along with the other 1,000 individuals, soldiers, that were supposed to be up there helping with this entire situation. He said himself, we're going to try and develop SOPs. We're going to try and develop strategies to handle the criminal activity. We've got some MPs that are available. And 2 weeks ago, I happened to be at an event in the district, and I had somebody who I was somewhat familiar with, former ICE agent, who said, listen, there's at least 4 cases of sexual assault, and there's more coming. So I think this is just the beginning of a very bad story that's going to continue to unravel. And if it's happening in Fort McCoy, Wisconsin, it's going to be happening at the other 5 Army posts as well. So I would yield to my friend, Mr. Tiffany.
Thank you, Representative Fitzgerald. Real quickly, I appreciate your comments earlier. You'd like to move on. Let's deal with these bills. But that's the problem. We don't get a hearing on stuff like this. None of this is being heard. Where is Secretary Mayorkas? Where is he? He should be right here. Why are we not having detailed hearings about how we're going to fix the broken immigration system in this country? Because it is out of control at this point, and it is a disservice to the American people, and it's a disservice to the legitimate Afghans that should be coming to our country.
Time of the gentleman has expired.
I yield back.
For what purpose is Mr. Royce seek recognition?
Move to strike the last word.
Gentleman is recognized.
Appreciate the chairman. That's the question. Where is Secretary Mayorkas? Where is President Joe Biden? Where is alleged border czar Vice President Kamala Harris? I can tell you where they're not. They're not on the border. Now, I just heard, and I honestly can't believe my ears, I just heard my colleague from Texas claim that the border is secure. That is laughably not true. It is a laughable assertion. And I've heard Secretary Mayorkas make the same claim. I'd like Secretary Mayorkas to make that claim in front of this committee. Why aren't we hauling him in front of this committee? I'd like him to have to answer on behalf of the people of Texas. I'd like him to answer to the questions that we have for him. I'd like him to answer for the 100,000 dead Americans dying of opioids across our country because fentanyl is pouring into our country via the southwest border, enriching cartels and empowering China. I want him to answer to those cartels making hundreds of millions of dollars. I want him to answer about the little girls getting raped, brands on their legs, burns from the cartels, threats of violence against their families, stash houses all over Texas, stash houses along the border, stash houses in Del Rio, all the way down to McAllen. I'd like him to answer for the dead migrants all over Texas. Dead migrants. 95 of them in Brooks County, Texas. You know what? Sheriff Benny Martinez is about 300 yards away from the room you all are sitting in. How about I go grab Benny Martinez, the sheriff of Brooks County? He can come down and talk to you about the 95 bodies of migrants that we have found scattered across that county in Texas. $3,000 an autopsy, $5,000 a burial for people that we have to go find out who they are and where they came from. How about the other counties all over South Texas with hundreds of migrants dying in the Texas heat, where ranchers have to go stumble upon their bodies, picked apart by vultures in the Texas heat? And I heard the gentlelady criticizing the state of Texas for daring to spend $3 billion to do what the federal government is refusing to do. Give me a break. The state of Texas is the only thing standing between complete, absolute lawlessness and a wide open border for our country. The Border Patrol, who I heard the gentlelady just refer to. Oh, I know the Border Patrol, she says. Well, go talk to them right now. There are a number of them in town right now. Brandon Judd is a few hundred yards down the road. Why don't we bring Brandon over to go talk about the state of the Border Patrol? While Secretary Mayorkas and Joe Biden and the White House press secretary beat up our Border Patrol agents for doing their job, riding horses, and then they get called racist. The modern day scarlet letter. Some of us aren't going to run from this ridiculous, scurrilous charge being leveled against hardworking Americans trying to defend our country. The DOJ Civil Rights Division being sent down to Del Rio. The President of the United States can't find his way to send additional resources to actually secure the border. But it sure as hell has time to go send the Department of Justice Civil Rights Division down to investigate men riding their horses trying to secure the border of the United States and impugning the character of those who are standing up when others will not. I darn right stand alongside the governor of Texas for sending the 700 or 800 people that were down in Del Rio to supplement Border Patrol. And had they not been there, we would have lost complete control of the situation. President Obama, just yesterday, made the clear point. We are a nation of states. We have borders, and open borders are unsustainable. The same president who, by the way, said a number of years ago, we simply cannot allow people to pour into the United States undetected, undocumented, unchecked, circumventing the line of people who are waiting patiently to get into the United States.
Go ahead, bro. I'm in committee, but I'll take a question real quick. Go ahead.
Oh, I'm going ahead.
Okay, let's get,
Mr.
our-
Correa,
our
you need to
Secretary
mute.
ready to go,
Please
okay?
mute your phone.
Former Secretary Jay Johnson said
Gentleman's-
1,000 a day was a
The
crisis.
gentleman's time has
We've had
expired.
5,000 to 7,000
The
a day for the
gentleman's
last
time-
6 months.
The
And
gentleman's
my
time-
colleague has the
the gentleman's
audacity
time
to
is
sit in
ex-
that chamber and say the border
The
is secure
gentleman's time has expired.
when our eyes tell us the complete opposite.
Gentleman's time
Mr.
has
Chairman,
expired.
call the Secretary
A
of
report-
Homeland Security before this committee and make him
A
answer
reporting quorum
to the
being
people's
present,
representatives
the
for
question
his
is now reporting the
impeachable
bills as amended
acts in
and
failing
blocked
to faithfully
favorably to
execute
the
the laws of
House.
the United States.
Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it, and the bills are ordered reported favorably. Members will have 2 business days to submit views. Without objection, H.R. 681 will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call-
Chairman, we can't hear you.
I don't know why not.
Mr. Chairman, you're on mute.
No. Pursuant to notice, I now call up H.R. 2883, the Stop Stalling Access to Affordable Medications, for purpose of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 2883 to enable the Federal Trade Commission to deter filing of
Without
shams.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Today, 1/4 of Americans report that it is difficult to afford their medicines. In fact, exorbitant medical bills are one of the many reasons Americans seek bankruptcy relief. It is painfully clear, however, that the soaring cost of health care is not just bad for Americans' pocketbooks, it is also bad for the health and well-being of American families. As I've said before, it is unacceptable that many seniors cannot afford the arthritis medication they need to perform everyday tasks, such as buttoning their coats or opening a jar without excruciating pain. It is unacceptable that hundreds of thousands of cancer patients are reportedly delaying life-saving care, cutting their pills in half, or skipping treatment entirely due to high drug prices. And it is unacceptable that those suffering from diabetes must worry about the life-threatening consequences of not being able to afford insulin because of its exorbitant cost. These trends have only worsened as a result of the pandemic, which has wrought tremendous hardship in our communities. As the Biden administration recently noted, these high prices are in part the result of lack of competition among drug manufacturers. The largest pharmaceutical companies are able to wield their market power to reap average annual profits of 15 to 20%, as compared to average annual profits of 4 to 9% for the largest non-drug companies. Today, the committee will tackle this crisis by considering a package of bipartisan legislation that will lower drug prices by prohibiting anti-competitive tactics that block or delay access to safe and affordable medications. The first of these bills is H.R. 2883, the Stop Stalling Access to Affordable Medications Act, bipartisan legislation introduced by Representatives Hakeem Jeffries and Ken Buck to prohibit the abuse of citizen petitions by branded drug companies to keep lower-cost generic competitors off the market. The citizen petition process provides an avenue for the public to raise legitimate scientific and health concerns about drugs under review by the Food and Drug Administration. But instead of serving this important function, this process has often been misused by brand-name drug manufacturers to stifle competition from generics and biosimilars. These companies bombard the FDA with sham petitions, lacking any scientific or health-related basis, solely to flood the agency with paperwork to grind the approval process to a halt. The Stop Stalling Access to Affordable Medications Act will help put an end to these abusive and anti-competitive practices. The bill explicitly provides that the submission of a sham petition to prevent or delay entry of a generic or biosimilar competitor is illegal under antitrust law. It also gives the Federal Trade Commission authority to seek a civil penalty and other appropriate relief in response to the filing of sham petitions by drug manufacturers. Importantly, this measure applies only to petitions that are used for anti-competitive purposes as a pretext for attempting to interfere with the approval of a competing drug. In doing so, the bill carefully adheres to existing case law and constitutional principles. This legislation strikes an appropriate balance that will help lower the cost of prescription drug prices by preventing unnecessary delays in the approval of lower-cost generic competitors while preserving the public's right to petition the government. This past July, the Senate Judiciary Committee advanced a substantively identical bill out of Commerce on a unanimous vote, and I hope this committee will act in a similar manner today. I thank my colleagues, Congressman Jeffries and Subcommittee Ranking Member Buck, for their leadership on this important bipartisan legislation. I also appreciate the work of Carolyn Maloney, Chair of the Committee on Oversight and Reform, who has led a comprehensive investigation of drug pricing in her committee. The Oversight Committee's investigation has uncovered significant new evidence that underscores the urgent need for this legislation. I urge my colleagues to support this potentially life-saving measure. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Citizen petitions allow Americans to bring health and safety concerns to the attention of the Food and Drug Administration. They may be filed in a number of contexts, including when a generic manufacturer is working to get FDA approval for a product. Brand name manufacturers have been accused of filing so-called sham petitions with the intent of slowing the entry of generic competitors. These sham petitions are designed to delay or prevent FDA's approval, not to improve the final product. The Trump administration took responsible and reasonable actions to address sham citizen petitions. The Trump administration explained that citizen petitions have rarely delayed specific generic drug approvals, but still the Trump administration took steps to make future gamesmanship even harder, including by issuing new FDA guidance in 2019. The FDA also put in place other reasonable measures like annual reporting to Congress and, when appropriate, to antitrust enforcers. If and when sham citizen petitions are filed, existing antitrust law already permits enforcers to sue bad actors, but this bill goes further, to give more power to unelected, unaccountable bureaucrats in the Biden FTC. I have concerns about needlessly giving more power to any administrative agency, let alone the out-of-control Biden Federal Trade Commission. Sham citizen petitions are obviously something that no one wants interfering with the approval of drugs, but this bill is not the right approach, in my judgment, to this problem. I yield back the balance of my time.
The gentleman yields back the balance of his time. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2883, offered by Mr. Nadler of New York.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. The amendment in the nature of a substitute makes technical changes to conform the text of H.R. 2883 to the version of Senate 1425 that was advanced favorably by the Senate Judiciary Committee on a unanimous basis on July 29th. I appreciate the work of my Senate colleagues on this legislation, and I urge all members to support the amendment. Are there any amendments to the amendment in the
Mr. Chairman.
Substitute? For what purpose does Mr. Jeffrey seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I rise in support of H.R. 2883 to stop stalling access to Affordable Medications Act, a bipartisan and bicameral bill to crack down on abusive behaviors in the pharmaceutical industry that contribute to the outrageously high cost of life-saving prescription drugs in America. Last Congress, this bill passed out of the Judiciary Committee by a voice vote, led in part by then-ranking member Doug Collins. And earlier this year, it was passed by the Senate Judiciary Committee unanimously. Prescription drug prices are higher in the United States than in any other industrialized country in the world. And
more than 25% of the American people report that they are unable to afford their basic day-to-day medication. Since 2011, the cost of 4 of the top 10 prescription drugs in the United States have increased by more than 100%. Generic drugs provide Americans with a more affordable option while maintaining the same level of safety, efficacy, and quality. Generics are typically sold for an estimated 80 to 85% less than the price of a brand name drug. Additionally, when generics enter the market and the brand name drugs have to compete, it can dramatically reduce prices. Unfortunately, brand name companies often use stalling tactics to delay the launch in the market of generic products, allowing these brand name companies to continue to profit by keeping prices artificially high. One such tactic is filing sham citizen petitions with the FDA. Congress designed the citizen petition process to let ordinary, everyday Americans file petitions that raise legitimate public health and safety concerns with drugs under review by the FDA. However, some drug companies have hijacked this process and started flooding the FDA with fake petitions crying foul about meritless safety or efficacy concerns related to generic drugs under consideration. Brand name drug companies file at least 92% of the citizen petitions against generic drug applications. That's correct. 92% of the citizen petitions against generic drug applications are filed by brand name multi-million-dollar or billion-dollar companies. The FDA ultimately rejects these fake petitions over 90% of the time. But since the FDA is required under law to respond to each petition, this abuse wastes time and taxpayer-funded resources. And while the sham petitions are under review, generic drugs and lower costs remain stalled and out of reach for many everyday Americans. American people are thus the victims of these fraudulent schemes and stalling tactics, and we must end this abuse once and for all. Stop Stalling Access to Affordable Medications Act will make it explicitly unlawful and anti-competitive behavior under the Federal Trade Commission Act to use sham petitions to stall generic drug competition. This will strengthen the ability of the FTC to challenge citizen petition abuse in court and appropriately, when required, fine drug companies that are abusing the system, which hopefully will serve as a strong deterrent against this behavior. H.R. 2883 also protects the fair use of citizen petitions with respect to legitimate public health concerns, which is an important part of the review process. Let me thank the co-leads of this legislation, Ranking Member Buck, Chairman Nadler, and Chair of the Antitrust Subcommittee, David Cicilline, for their partnership and leadership in this effort. This is the wealthiest country in the history of the world. No American should ever have to choose between putting food on the table, paying the rent, or affording life-saving medications. We can take an important step to lower out-of-control drug costs by passing the Stop Stalling Act. I urge you to support this legislation, and I yield back the balance of my time.
Gentleman yields back. For what purposes does Mr. Cicilline seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and thank you for holding today's important markup. Across the country, the skyrocketing costs of prescription drugs are ruining lives. Individuals living in the United States spend more on prescription drugs, over $1,500 per person annually, than residents of any other developed country. Over the past decade, American patients have experienced a steep increase in their out-of-pocket costs for many top-selling drugs. Professor Robin Feldman of UCLA Hastings Law School recently testified before the Antitrust Subcommittee that out-of-pocket costs have increased by more than 50% for the majority of these drugs, and many others have more than doubled in price. These high costs can lead patients to delay care, skip doses, or even forego treatment altogether. According to a recent Gallup poll, about 18 million Americans, nearly 10% of U.S. adults, said that they were unable to pay for at least one of their prescription medications in the past 3 months. For households earning less than $24,000 per year, that percentage doubles to a staggering 20% of patients unable to afford their medication. Faced with the impossible choice of putting limited funds towards rent or food and paying for medication, about 1 in 3 Americans are forced to skip life-saving medications due to cost. Prices are skyrocketing and people are going bankrupt and even dying because they cannot afford their prescription medicine. At the same time, despite decades of rising costs, the United States ranks dead last in health outcomes among similarly developed countries. As a result of this widespread and worsening situation, there is a consensus from across the political spectrum that Congress must take action to lower prescription drug prices. The package of bipartisan bills that we're considering today provides us with an opportunity to give some measure of relief to the 18 million Americans struggling to afford their medication and the 34 million Americans who have lost a loved one because they could not afford medical treatment. The nonpartisan Congressional Budget Office estimates that these bills will deliver $2 billion in savings for Americans over the next decade, freeing up hard-earned taxpayer dollars to invest in our future. This past July, our Senate counterparts did their job, reporting every one of these bills out of committee with either unanimous or strong bipartisan support. And today it is time for us to do ours. I do not intend to let these many millions of Americans down, and I hope my colleagues on both sides of the aisle are willing to stand up to Big Pharma and do the same. We must prioritize the lives of patients over additional profits for pharmaceutical companies and their shareholders. The first of these bills is H.R. 2883, the Stop Stalling Access to Affordable Medications Act, which prohibits a branded drug manufacturer from abusing the FDA's citizen petition process to block generic entry and artificially extend its monopoly. As Professor Michael Carey of Rutgers Law School testified earlier this Congress, this anti-competitive conduct blocks or delays access to affordable medications without any offsetting benefits. I want to thank my friend and colleague, Mr. Jeffries, for his leadership on this legislation and urge my colleagues to support H.R. 2883, which will make a real difference in the lives of those we serve. And with that, Mr. Chairman, I yield back.
The gentleman yields back. For what purpose? Does Ms. McBath seek recognition?
Thank you, Mr. Chairman. I move to strike the last word, and as my colleague, Representative...
Gentlelady is recognized.
Thank you. As my colleague, Representative Cicilline just mentioned, we want to thank Congressman Jeffries for taking the lead on this, and I'm proud that the Judiciary Committee is again working in a bipartisan effort to reduce the cost of prescription drugs. And I was pleased to support this effort last Congress, and I'm again standing strong in support of these bills. I've said over and over again, I'm a 2-time breast cancer survivor, and I know all too well how serious a diagnosis can be, and it completely changes your life. And I have to say, my treatment was exhausting, both physically and emotionally. And I was truly blessed to be able to afford my medication. But unfortunately, that is not the reality of all Americans. And my constituents are telling me over and over again that affordable health care and lowering the cost of prescription drug prices are the top priority for their families. And I know that affordable health care was a top priority before the pandemic, and it still remains to be so even today. And too often I've heard stories of families that are forced to make impossible financial choices as a result of their illnesses. And do they buy gas, for the cars, or how do they get their kids to school and the groceries that they need to feed their family, or the medications that they need to survive? And no one should ever have to be forced to make such questions and decisions, forced by those questions and decisions. Yet we know that American families are doing this every single day. So I'm just really excited because together these bills, address many practices that are known to be keeping, prices high and reducing competition, whether by paying off competitors, abusing the system, or scheming to prolong their hold on the market. And today we're going to take, resounding action to lower the cost of prescription drugs by ending these practices, which we must do. And I'm really proud to support these bipartisan bills, and I urge my colleagues to join me in supporting them today. And I hope that these bills will really bring down the costs and prices to Georgians, particularly in my own home state and in my district, and to all the families across the nation. With that, I'm really excited to support these bills today, and I yield back the balance of my time.
The gentlelady yields back. For what purpose does Ms. Garcia seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and I too want to thank you for bringing this bill forward and thank Mr. Jeffries, our colleague who's worked on this last time and again brings it to us today. Thank you for his leadership and his dedication to this bill. And to the other two in this group, because today I think we do great steps in making sure that we have more affordable prescription drugs for all Americans, and we are also, in turn, promoting healthy competition. According to polling from the nonpartisan Kaiser Family Foundation, almost 80% of Americans believe drug costs are too high. I know that anytime I visit a senior center in my district, the one thing that they always complain about, of course, next to changes in Medicare to include glasses, hearing aids, and dentures, the next thing they always talk about is the high cost of drugs. Put simply, millions of Americans cannot afford their medicines. They cannot afford the price because of the lack of competition, because of some of the things that we're addressing today. Because drug companies may be making their profits, but none of that is getting back to the consumer. Americans should not have to choose between paying for medicines, what they need, or pay for food, utilities, or rent, or even gasoline in their car. According to Unidos USA Action Fund, Latinos in the United States are more likely to live with chronic health conditions that require prescription medicines than to stay healthy, and are also more likely to be uninsured. As a result, Latinos are disproportionately impacted by high drug costs. While others have decided to ignore these issues, we choose to act and deliver for the people. For this reason, today we're moving forward with marking up this group of bills, which I totally support. They will impose much-needed relief, transparency measures, and protections for vulnerable communities across the country. I support them, and I ask all my colleagues to do the same. Again, Mr. Chairman, thank you. And I also ask for unanimous consent to enter for the record an article titled A Vicious Cycle of Health Inequity, written by the Unidos USA Action Fund.
Without objection.
And with that, Mr. Chairman, I just urge all my colleagues to support this group of bills so that we can bring some relief to Americans across the country. With that, I yield back.
Gentlelady yields back. For what purpose does Mr. Issa seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2883, offered by Mr. Issa of California, page 5, line 15. Insert, except that no rule may be issued based on this section before the period at the end.
The gentleman is recognized for the purpose of explaining his amendment.
Thank you, Mr. Chairman. This amendment inserts language to make clear that H.R. 2883 cannot serve as grounds for new or unfair methods of competition rulemaking under Section 5 of the Federal Trade Commission Act. Although I support the underlying intent of the bill, I think at this time it would be inappropriate to transfer an unreasonable amount of power to the Federal Trade Commission under Section 5. Existing authorities under this act, which have historically passed on a bipartisan basis, would be sufficient to meet the requirements intended by the authors. Just yesterday, Commissioner Wilson, Christine Wilson, testified how the Biden administration's radical FTC leadership has upset longstanding processes and norms. Now, that's one commissioner's opinion, but I share that opinion that, in fact, this is a time in which to remain bipartisan, as this legislation has historically been, requires that we do no harm and that we do only that which is necessary. For that reason, I believe this is a non-controversial amendment, one that would put us in a position in which we could allow for this stopping of stalling by the pharmaceutical companies, while at the same time not transfer an unreasonable amount of authority to the Federal Trade Commission. For that reason, I move this amendment and yield back.
The gentleman yields back. The point of order is, does the gentleman insist on his point of order?
I withdraw my point of order, Mr.
Point
Chairman.
of order is reserved. For what purpose does Mr. Cicilline seek recognition?
We wish to speak in opposition to the amendment.
The gentleman is recognized.
Mr. Chairman, I rise in opposition to the amendment and would say at the outset it's important to remember that we are passing legislation today that has already passed out of the Senate. And so it's important that we not make modifications. These bills have enjoyed consistent bipartisan and bicameral support. The House Judiciary Committee voted to advance substantially similar versions of these bills on a bipartisan unanimous basis during the 116th Congress. All three of these bills were passed out of the Senate Judiciary on July 29th, as I mentioned earlier, with either unanimous or strong bipartisan support. And out of deference to our Senate partners, and because these issues are so important that we move expeditiously, we can't accept any amendments, or I would suggest that we not support this amendment, and obviously would continue to work with our Senate counterparts to address any issues that might arise before the bill. But I would also say that there's nothing in this legislation that expressly provides the FTC with the authorization, although the amendment you're offering may in fact do that by implication, which I'm sure is not Mr. Iss's intention. But I would just urge that the amendment be rejected for all those reasons, and I yield back.
Gentleman yields back. Does anyone else seek recognition? Seeing none, the For what purpose does the gentlelady from Florida seek recognition? From Texas seek recognition.
Thank you very much, Mr. Chairman. Let me rise to support the underlying legislation and indicate we're in the midst right now of trying to provide a more expanded opportunity for Americans as it relates to health care, dealing with Medicaid and dealing with Medicare. But I am very grateful for this legislation that goes to the heart of what I hear from so many of my constituents. But interestingly enough, I heard it from someone as I was walking across the plaza, Mr. Jeffries, a mother who had one child suffering from a diagnosed mental illness, another child suffering from how should I say it, something along the lines of a severe autism. But what was mostly striking as she pleaded for help, having nowhere to go, is the high cost of drugs. To be able to help both children. And without those drugs, the children could not live in the same home together. So the idea of dealing with legislation that provides for the more competitive and more effective pricing of prescription drugs is life-saving. And I think it is particularly important that it came out of the Judiciary Committee, because the concept of the Judiciary Committee is for justice. So I want to just take this note that according to the U.S. Department of Health and Human Services, Americans spend more on prescription drugs than residents of any other developed nation, because branded drug manufacturers have so much to lose from the entry of a genetic competitor. They're highly incentivized to engage in anti-competitive conduct to block or delay generic entry of generic drugs, which harms American consumers through higher drug prices and worse healthcare outcomes. I would hope that the underlying bill will pass, and the gentleman's amendment, as it may interfere with these ideas that come forward. Anti-competitive tactics include pay-for-delayed settlements, which occur when a branded drug company pays its potential generic competitor to abandon a patent challenge and delay entering the market with a lower-cost generic. And so I'm interested in the whole series of bills that we will have before us that will provide as I've said earlier today, in another setting, a lifeline. And so I oppose the existing amendment and ask for support of the legislation. With that, Mr. Chairman, I will yield back my time.
Gentlelady yields back. The question occurs on the amendment. All in favor say aye. Aye. No. No. All in favor say aye.
Aye.
All opposed say no. No.
No.
The noes have it.
Mr. Chairman, on that, I ask for a recorded vote.
Recorded vote has been requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren. Ms. Jackson Lee. Ms. Jackson Lee votes no. Mr. Cohen.
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Jeffries votes no. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Jayapal.
No.
Ms. Jayapal votes no. Ms. Stimmings. No. Ms. Stimmings votes no. Mr. Correa.
No.
Mr. Correa votes no. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia.
No.
Ms. Garcia votes no. Mr. Neguse. Ms. McBath.
No.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean. Ms. Dean votes no. Ms. Escobar. Mr. Jones. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush.
Bush votes no.
Ms. Bush votes no. Mr. Jordan. Mr. Jordan votes yes. Mr. Shabbat.
Aye.
Mr. Shabbat votes aye. Mr. Gomert.
Aye.
Mr. Gomert votes aye. Mr. Issa. Mr. Issa votes aye. Mr. Buck. Mr. Buck votes no. Mr. Gates. Mr. Johnson of Louisiana.
Full disclosure that I have known, mentored.
Mr. Biggs.
Aye. Aye.
Mr. Biggs votes aye. Mr. McClintock. Mr. Stubbe. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes aye. Ms. Fishbach.
Aye.
Ms. Fishbach votes aye. Ms. Sparts.
Yes.
Make sure that we are moving
Ms. Sparts votes yes.
I do not
Mr.
want to
Fitzgerald.
minute, so thank you, Chairwoman, and thank you all, and I look forward
Mr.
to
Benz.
an active and.
Mr.
and
Benz
critical-
votes yes.
Thank you
Mr.
so much.
Owens.
Thank you.
Members need to mute their microphones except when speaking.
Owens, no.
Mr. Owens votes no.
How am I recorded?
Ms. Bass, you are not recorded.
Ms. Bass votes no.
Ms. Bass votes no.
Mr. Chairman, how am I recorded?
Ms. Escobar, you are not recorded.
Escobar votes no.
Ms. Escobar
How am
votes
I recorded?
Mr. Liu, you are not recorded.
No.
Mr. Liu votes no.
How is Massey recorded?
Mr. Johnson of Louisiana, you are not recorded. Mr. Johnson of Louisiana votes no. Aye, sorry. Mr. Massey, you are not recorded.
Massey votes aye.
Mr. Massey votes aye.
Madam Chair,
how am I recorded?
Mr. Johnson of Georgia, you are recorded as aye.
Change that to no, please.
Mr. Johnson of Georgia votes no.
Mr. Chair, how am I recorded?
Mr. Deutsch, you are not recorded.
I vote no.
Mr. Deutsch votes no.
Mr. Chairman,
Ms. Lofgren?
Chairman,
Ms. Lofgren?
I vote no.
Ms. Lofgren votes no.
Are there any other members who have not been recorded who wish to be recorded? The clerk will report.
Mr. Chairman, there are 13 ayes and 24 noes.
The amendment is not agreed to. For what purpose does Mr. Biggs seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I don't think there's anybody in this room that probably are on our committee that would disagree that prescription drug prices are too high. But I think this bill is in danger of overpromising and will underperform because it doesn't get at the root cause of high drug prices, this particular bill. So under its existing authority, under Section 5 of the FTC has sued to stop sham petitioning in the past. And in October of 2018, then FDA Commissioner Gottlieb said, the record shows that citizen petitions have rarely delayed specific generic drug approvals. Further, the most recent information suggests that sham citizen petitions are not a significant problem. In fiscal year 2020, only 7 relevant citizen petitions were filed with the FDA. Think about that, 7. Of those, none resulted in any delay to approving product applications. And further, of those 7 citizen petitions submitted, the FDA did not conclude any were submitted with the primary purpose of delaying an application's approval. When testifying before the Judiciary Committee, Alden Abbott, who is a senior research fellow at Mercatus Center, said, there is the risk that at some future time, overzealous antitrust enforcers may mistake.
You want brownies or?
I don't know. I don't want brownies. I'd ask everybody to turn off their mic unless they're talking, Mr. Chairman. Overzealous antitrust enforcers may mistakenly characterize genuine petitioning as sham activity. In short, a bit of antitrust regulatory humility is in order to avoid chilling genuine petitioning activity. And there are genuine activities. And so I'll be opposing this particular piece of legislation. And I'll ask, Mr. Chairman, if I can submit for the record the 13th annual report on delays and approvals of applications related to citizen petitions and petitions for stay of agency action for fiscal year 2020 by the FDA.
Without objection.
I thank you, Mr. Chairman, and with that, I'll yield back.
Gentleman yields back.
Mr. Chairman, would the gentleman yield before he yields back? Would that be all right?
He's yielded back. Do you You want to strike the last word?
I move to strike last word.
Gentleman is recognized.
If the gentleman, Mr. Biggs, is still there, I'd like to ask him a question and engage in colloquy if he is willing.
I'm happy to let you ask any question you want. I don't guarantee that I'll answer any of them, though.
My question is simply, would the gentleman agree with me that a delay tactic like this petition, regardless of how many have been offered recently, but a delay tactic like this petition is bad for consumers?
It depends, Mr. Buck. I thank you. I think if it's done for delay purposes only, yes, it would be bad. But if there are legitimate concerns, that would be necessary to determine. And what the FDA has determined, at least of recent vintage, none of the citizen petitions have been for the purpose of delay. And in fact, there have been very few filed recently. So it does kind of make me wonder about the extent of the concern that has been expressed here today.
Well, I appreciate that, and I appreciate the gentleman's concern. The agreement that I understand we have is that a sham petition that would delay a generic drug would be wrong, and obviously a concern, I think, to everyone on this committee. Now, the reality is that this bill has not just been offered this time, this year, this Congress. It has been offered for a number of Congresses, and I think Congress has sent a very clear message that there is a concern, whether the bill has been passed or not, there is a concern, and that Congress is looking at these sham petitions, and so that may very well be the reason why there have been fewer sham petitions filed. And I appreciate the gentleman's recognizing that there are fewer sham petitions and fewer petitions overall filed. I would suggest that one of the reasons is that Congress has been debating this issue for a period of time, and I think it goes to the necessity to pass this bill and to make sure that there aren't sham petitions. This bill does not stop legitimate petitions from being filed. It stops sham petitions, and I would ask my colleagues to support this bill, and I yield.
Would the gentleman yield?
Oh, I will. I'm sorry.
Thank you, Mr. Buck. I appreciate that. I just want to say that I think you and I are in agreement that when Congress even debates some of this action, it sends a message, and hopefully it has been salutary and one of the reasons for slowing down these petitions. But I also would suggest that Section 5 of the FTC Act also allows for the FTC to prosecute or pursue sham petitions, and they have actually done so in the past. So hopefully, even our discussion today will alert the FTC that if there are sham petitions going on, which they didn't find that at least over the last fiscal year, that they would take action against a sham petition using the authority that they already have. And I appreciate the gentleman for yielding, and I'll yield back.
And I yield back, Mr. Chairman.
Gentleman yields back. Are there any other amendments to the amendment in nature of a substitute? If not, the question occurs on the amendment in nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
No.
The opinion of the chair, the ayes have it. The amendment to the nature of a substitute is agreed on. Reporting quorum being present, the question is on the motion to report the bill H.R. 2883 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably.
Mr. Chairman, may we have a roll call vote, please?
Recorded vote has been requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Stimmings? Ms. Stimmings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Nagus?
Aye.
Mr. Nagus votes aye. Ms. McBeth?
Mr. Chairman, how am I recorded?
Ms. Lofgren, you are not recorded.
Aye.
Ms. Lofgren votes aye. Ms. McBeth?
Aye.
Ms. McBeth votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Mr. Jones?
Now I don't have the meeting. It's a Zoom meeting.
Ms. Ross?
Ross
votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Very loud.
Ms. Bush votes
So
aye.
anyway, sometimes they just
Mr.
gave
Jordan.
Members will
say
remember
your
to
name,
mute their
they
mic.
couldn't understand it. so
Members will
you're cold.
mute themselves, please.
Chairman, how is Swalwell recorded?
Mr. Swalwell, you are not recorded.
Aye.
Mr. Swalwell votes aye. Mr. Jordan? No. Mr. Jordan votes no. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes no. Mr. Isa? No. Mr. Isa votes no. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs?
No?
Mr. Biggs votes no. Mr. McClintock? Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey?
Massey votes no.
Mr. Massey votes no. Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald?
Yes, and we're gonna Brenda line.
Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes aye. Mr. Raskin, you are not recorded.
Hold on.
Mr. Raskin votes aye.
How am I recorded?
Mr. Chairman, how am I recorded?
Ms. Bass, you are not recorded.
Aye.
And we know the
Ms.
district.
Bass votes aye. Ms. Escobar?
Mr. Chairman, how,
Right, that's-
Escobar is a yes?
Yeah.
Ms. Escobar votes yes.
How am I recorded?
Mr. Shabbat, you are not recorded.
Aye.
Mr. Shabbat votes aye.
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
Aye.
Mr. Jones votes aye.
How am I recorded?
Mr. Liu, you are not recorded.
Aye.
Mr. Liu votes aye.
How is Mr. Gates reported?
Mr. Gates, you are not recorded. Mr. Gates votes aye.
Are there any other members who wish to vote who haven't voted?
Mr. Chairman, this is Congressman Roy. How am I recorded?
Mr. Roy, you are not recorded.
Aye.
Mr. Roy votes aye.
Are there any other amendments? Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 31 ayes and 9 noes.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2891, the Preserve Access to Affordable Generics and Biosimilars Act for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 2891, to prohibit prescription drug companies from compensating other
Without
prescription drug.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2891, the Preserve Access to Affordable Generics and Biosimilars Act, is a bipartisan bill that I introduced along with Representative Ken Buck to prohibit anti-competitive settlements, also called pay-for-delay agreements, that block access to affordable prescription drugs. These anti-competitive agreements allow branded drug companies to pay off a generic competitor to delay entering the market with a lower-cost generic product. The result is that the brand-name drug company gets to keep its monopoly, and the generic gets paid off with a portion of the monopoly profits. Pay-for-delay agreements result in a financial windfall for both drug companies, but consumers inevitably lose. As the Biden administration recently noted in its executive order on promoting competition in the American economy, these deals between generic and brand name manufacturers reduce innovation, reducing new drug trials and R&D expenditures. In response to this problem, H.R. 2891 would establish that these agreements are presumptively illegal under the antitrust laws and would authorize the Federal Trade Commission to impose significant penalties on companies that engage in these pay-for-delay schemes. Although the Supreme Court held in FTC versus activists that pay-for-delay agreements could violate the antitrust laws, the FTC expends significant resources challenging what appear to be clear violations. This legislation would address that problem by requiring courts to view such agreements as presumptively unlawful. According to the Nonpartisan Congressional Budget Office, this legislation would save American taxpayers over $500 million over 10 years due to the high costs imposed on our healthcare system by this anti-competitive conduct. This bipartisan legislation passed unanimously out of the committee last Congress, and this past July, an identical companion to the bill was advanced favorably by the Senate Judiciary Committee on a bipartisan basis. I urge my colleagues to take similar action and to support this important initiative. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. H.R. 2891 creates a presumption of liability when the FTC decides to challenge a certain type of settlement agreement known as a reverse payment settlement. This type of agreement may occur in patent litigation when a brand name firm sues a generic manufacturer. In a reverse payment settlement, the brand name plaintiff will pay or provide other compensation to the generic defendant. In exchange, the generic drug company will agree to delay when its product reaches the market. In 2013, the Supreme Court decided that these type of settlements were not immune from antitrust scrutiny. In particular, the court held that while reverse payment settlements may violate existing federal antitrust laws, they may also have benefits under certain circumstances. In addition, these settlements trigger reporting requirements to the Justice Department and the FTC. At its core, this bill is designed to give more power to the FTC. The Biden FTC, frankly, now is abusing its power, like by using merger review authority to ask questions about environmental, union diversity, or equity issues. A Democrat commissioner on the FTC has said that the commission should be using its authority to address systemic racism. And a recent news article reported how the Biden FTC is implementing this objective. My concern about the FTC is not limited to substantive policy. As we just heard yesterday from Commissioner Wilson, the Biden FTC is engaging in significant process changes that ultimately hurt policy outcomes. Simply put, empowering the Democrat leadership of this agency makes no sense. If anything, we should consider taking away some authority from the FTC. I yield back the balance of my time.
The gentleman yields back without objection. All other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2891.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute makes technical changes to conform the text of H.R. 2891 to the version of S. 1428 that was advanced favorably by the Senate Judiciary Committee on a bipartisan basis on July 29th. I appreciate the work of my Senate colleagues on this legislation, and I urge all members to support the amendments. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. Cicilline seek recognition?
I move to strike the last word, Mr.
Chairman
Chairman.
is recognized.
Mr. Chairman, H.R. 2891, the Preserve Access to Affordable Generics and Biosimilars Act, would prohibit anti-competitive settlements, also called pay-for-delay agreements, between a branded and a generic drug manufacturer. These settlements literally involve a high-cost branded drug companies paying off a generic competitor to stay out of the market. As Professor Robin Feldman testified earlier this Congress, although the Supreme Court's favorable decision on activists paved the way for antitrust scrutiny of pay-for-delay schemes, companies have simply responded by making these agreements more complex and convoluted. Today, there continue to be numerous indications of value transfers from branded pharmaceutical manufacturers to potential competitors to keep safe, affordable drugs off the market. It is unthinkable that a pharmaceutical company with an expired patent can simply pay a generic or biosimilar company to delay their entry into the market with safe and affordable medications. This must end, which is why I strongly support Chairman Nadler's efforts to stop this abusive practice. H.R. 2891 does so by giving enforcers new tools to police pay-for-delay agreements. I thank the Chairman and Ranking Member Buck for their leadership on this issue, and I urge my colleagues to support this vital legislation. And would just say, in closing, that this issue remains one of the most urgent issues facing the American people, and I know facing many Rhode Islanders, the high cost of prescription drugs. And it's in large part because Big Pharma has had a run of the capital and has really had so much influence as we develop good public policy, which is hurting consumers, hurting patients, increasing costs. Today, that changes with the passage of this and the other pieces of legislation. I urge all my colleagues to stand on the side of their constituents against the power and influence of Big Pharma, bring down the cost of prescription drugs, and provide real service to those that send us here to Washington. And with that, Mr. Chairman, I yield back.
Gentleman yields back. For what purpose does Mr. Buck seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. The Preserve Access to Affordable Generics and Biosimilars Act strengthens the Federal Trade Commission's ability to challenge anti-competitive pay-for-delay agreements. Pay-for-delay agreements occur when a brand-name pharmaceutical drug company pays a competitor to keep a generic or biosimilar version of the branded drug off the market as part of a patent settlement. These deals delay access to cost-saving generic and biosimilar drugs and cost consumers and the government billions of dollars in higher prescription drug costs. In a free market, companies would be competing for consumers' business. In a pay-for-delay scheme, however, the branded company pays the generic to not compete. The generic is being paid to not bring its drug to market. The longer consumers must wait for a generic or biosimilar alternative, the longer they must pay the higher branded price. Pay-for-delay cases are also morphing from direct monetary payments to the generic manufacturer to paying the generic company with something else of considerable value in exchange for delaying entry to the market. For example, a generic might receive an exclusive license for the name brand company's drug patents, which creates a period of duopoly where there are only two competing products on the market and other generics are precluded from entry. Drug companies are clearly still engaging in pay-for-delay schemes despite what some may think. By bringing more generic and biosimilar drugs to the market instead of letting companies get paid to not compete, this bill will restore an element of competition and lead to lower prices for American consumers. I urge my colleagues to support this bill, and I yield back.
Back. The gentleman yields back. For what purpose does Mr. Bishop seek recognition?
I have an amendment at the desk.
Gentleman, the clerk will report the amendment.
Reserve a point of order, Mr. Chairman.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2891, offered by Mr. Bishop of North Carolina. Beginning on page 4, strike line 19.
Without objection, the reading of the amendment is waived. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. The underlying bill prevents generic drug manufacturers from settling with Big Pharma even when it would facilitate the early entry of generic alternatives. There is data to indicate that these settlements sometimes help prevent litigation and provide patients access to less expensive alternatives before the expiration of patents on branded drugs. One study that tracked 33 drugs subject to patent settlements between 2005 and 2012 found that these settlements saved the U.S. health system $25.5 billion from 2005 to 2012. Furthermore, these settlements have led to generic drugs being introduced 81 months prior to patent expiration on average. Completely outlawing such settlements would expose generic manufacturers to excessive litigation costs and deprive patients of cheaper generic alternatives sooner. My amendment would fix that by exempting settlement agreements that allow for early entry of a generic alternative before expiration of the branded patent. Cracking down on anti-competitive pay for delay schemes is sound policy, but we should not take away the ability of generic manufacturers to enter the market earlier with cheaper alternatives for American consumers. With that, Mr. Chairman, I yield back.
Gentleman yields back. Does the gentleman insist on his point of order?
I withdraw my point of order, Mr. Chairman.
Point of order is reserved. It is withdrawn, I'm sorry. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, I rise in opposition to the amendment.
Gentleman is recognized for 5 minutes.
First and foremost, Mr. Chairman, the first provision in this amendment, that page 2, line 24 strike or at the end, and page 3, line 3 strike period at the end of the semicolon, will end up resulting in a complete deleting of the enforcement provisions of this act. I'm not sure if that was Mr. Bishop's intention. It's beginning on page 4. Strike lines 19 and all that follows. That's the enforcement section of the bill. So that amendment would just gut the ability for the FTC to enforce the provisions that the bill enacts. So you're basically voting against the bill if you vote the amendment because you've gotten rid of the enforcement section. So that's the first thing. So we ought to just say that out loud if that's the intention, to gut the enforcement provisions so the bill is meaningless. But in addition, again, this is a piece of legislation where there's been very careful coordination with our Senate colleagues, passed out of the Senate Judiciary Committee, and we've worked extensively with stakeholders, with the FTC, to address these concerns through the inclusion of safe harbors in H.R. 2891. These safe harbors are carefully tailored to allow for certain pro-competitive settlement provisions, such as acceleration clauses. But this bill will serve really to promote early generic entry and the associated cost savings for taxpayers and for patients from generic competition. Consistent with this, the nonpartisan Congressional Budget Office estimates that this legislation will save taxpayers at least $500 million over the next 10 years. It's narrowly drafted to really only target anti-competitive settlements where a branded company is literally paying or transferring value to a low-cost generic or biosimilar drug company to stay off the market. And even in those instances, the companies can overcome the bill's presumption that this behavior is illegal by showing that the pro-competitive effects of the settlement clearly and convincingly outweigh its anti-competitive effects. So it's already built in. This amendment would strike the enforcement provisions, and I think, again, put us at odds substantially with the Senate version that's already passed. So with all of that, I'd ask my colleagues to reject this amendment, and I yield back, Mr. Chairman.
Gentleman yields back. Who else seeks recognition? For what purposes does Mr. Gates seek recognition?
To strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I'll be voting against the amendment of my friend from North Carolina for the reasons that the gentleman from Rhode Island laid out. We need these enforcement provisions. And all over America, people wonder why drugs, pharmaceuticals are so expensive, so much more expensive than everywhere else in the world. And the American taxpayer is far more generous than any other population of people when it comes to funding biomedical research. There is no major drug that has come on the market in this country that has not been funded in some part through its research by the American taxpayer. And yet these drug companies engage in anti-competitive practices that cheat the system and cheat our constituents. And so if you're wondering why the United States is so different The gentleman from Rhode Island laid it out. These drug companies literally set up phony, insincere settlement agreements so they're able to avoid that intellectual property being democratized and accessible and helping people. So I think it's a good bill. I'm glad we're doing it. I do have one concern that there seems to be a trend in the committee to vest in the FTC a substantial amount of authority. And when that authority could otherwise be exercised by the Department of Justice in some cases, you have to wonder why the FTC. And this committee has explored and investigated and frankly uncovered circumstances where the upper echelon officials at the Department of Justice don't exercise their full vigor in the pursuit of people cheating the system because there's a revolving door and they want to go work for big pharma or big tech or big insurance. And so they're, in many cases, the parasite that's trying to not kill the host. They want to go out there and act as if there's going to be some enforcement action, and then oftentimes that doesn't happen. My hope is that with the authorities that we're vesting in the FTC, that we won't see that same dynamic and there'll be protections, and perhaps my colleague from Rhode Island would, I could yield to him to allay my concerns.
Yeah, no, I thank the gentleman for yielding and for your support of the position I articulated. Just to say that the FTC has over time developed expertise in the drug pricing and pharmaceutical area that makes their handling these matters, I think, more efficient because of that expertise. The DOJ typically does the insurance component of it. So I think you can have some confidence that we're not expanding that authority, but that there's real expertise there and it's probably more efficient and more cost-effective to do it there. And I yield back.
I appreciate the gentleman's explanation. I yield to my friend from Colorado.
And I would just like to echo what my friend from Florida mentioned about the Department of Justice, but also I think it is incumbent, and I would ask the gentleman from Rhode Island his thoughts on this, I guess, but I think it's incumbent on us as we continue to give the Federal Trade Commission more resources and more tools to deal with these very serious problems. And I think my friend from Florida made a great point about the cost of drugs and if anything we can do to chip away at the ridiculous cost of drugs in this country, even though I am a beneficiary, and I'm sure many people here are beneficiaries of some of those innovations that have occurred by pharma. I still think that we have a duty, Mr. Cicilline, to make sure that we conduct oversight on the Federal Trade Commission and that we bring some of their officials in our subcommittee and ask them questions to make sure that they are acting within the scope that Congress intends them to act in. I understand from some of my colleagues on this side of the aisle, there are concerns about a runaway commission. I don't necessarily share those concerns, but I think it would be important for the American people to hear directly from those folks. And I yield back from the gentleman from Florida and would ask if he would recognize the gentleman from Rhode Island.
I'd yield to the gentleman from Rhode Island.
I thank the gentleman for yielding. And yes, I think, with the renewed interest and advocacy for strong antitrust enforcement by the Judiciary Committee, not just our subcommittee, but other members as well, it will mean not only additional resources, but additional oversight. I think, for example, the moment the Attorney General for the Antitrust Division is confirmed, I hope we will have him before either the full committee or the subcommittee quickly, as well as the FTC. I think we have an opportunity and a responsibility to conduct robust oversight to ensure that the resources that we are devoting to this work is being executed appropriately, and I look forward to working with all of my colleagues on the subcommittee to make sure that that happens, and I thank you.
Mr. Chairman.
I appreciate
Oh, sorry.
Oh, I'm sorry.
I would simply say I'm loving the antitrust energy coming out of the Judiciary Committee, in particular subcommittee, and I'd yield back.
The gentleman yields back.
Mr.
Chairman.
The gentleman yields back. That object.
If you'd recognize me, Mr. Chairman.
What purpose is Mr. Bishop seek recognition?
Mr. Chairman, I think Mr. Cicilline is correct. I think there's a drafting defect. I've made the point, I think, which I think is that I'm not sure all these should be prohibited. I withdraw the amendment.
The amendment is withdrawn. There are votes on the floor, and pursuant to Rule 2, there are votes on the floor. The committee will stand in recess until after the votes.
Oh.
We haven't- Okay, okay. The markup will come to order. We will resume consideration of the amendment in nature of a substitute to HR 2891. Who seeks recognition?
Mr. Chairman,
For what purposes, Mr. Shabbat seek recognition?
move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Take too long. I think we're all aware that prescription drug prices are skyrocketing and that they've been doing that for quite some time now. I personally listened to heartbreaking stories from my constituents who are skipping medications simply because they cannot afford to take them the number of times that they've been subscribed. And that can be a very dangerous scenario and one that's probably all too familiar. These bills that we're now considering are aimed at lowering prescription drug prices by addressing some of the gamesmanship that occurs in the patent process. That's not to say that companies that invest billions of dollars in research and development of a new drug shouldn't have exclusivity when they bring those drugs to market, but it shouldn't be in perpetuity. Authorized generics are prescription drugs that are often produced in conjunction with branded prescription drugs. They have the same chemical composition as branded drugs, but are offered as at a generic price, so it's much more affordable to consumers. Authorized generics play an important role in helping to keep the price of prescription drugs affordable. What we must consider, particularly with legislation like HR 2891, is the effect that these bills collectively might have on all generics, including those which are authorized. I applaud the work of Chairman Nadler on this legislation, and I hope that we can continue to work together in a bipartisan manner on additional legislation which will help lower prescription drug prices. And I want to commend really many members on both sides of the aisle for working together on a number of pieces of legislation today. And with that, I yield back.
Gentleman yields back. Does anyone else seek recognition? For what purposes, Mr. Jackson Lee seek recognition? Gentlelady is recognized.
Thank you very much, Mr. Chairman. I rise in support of Preserve Access to Affordable Generics and Biosimilars Act. And I join in the effort of bipartisanship on what really impacts so many in our respective districts. This legislation will establish that certain pay-for-delay agreements are presumptively anti-competitive. It's almost unbelievable that these tools exist, and they would authorize the FTC to initiate an enforcement proceeding against parties to such an agreement involving the sale of a drug or biological product. I think it is appropriate for any company to have the opportunity to defend in or explain that it is not pay-for-delay or it's something else. But the pay-for-delay agreements are financial agreements in patent litigation between brand name and generic pharmaceutical companies that take the form of a patent litigation settlement agreement in which the branded drug firm pays its potential generic competitor to abandon, slow down, don't show up a patent challenge, and delay entering the market with a lower cost generic product. Always the explanation has been we need to recover our cost of research, and I certainly am no stranger to the idea of R&D, having worked on these issues, started off my career here in Congress on the Science and Technology Committee, and R&D is very important. But according to the FTC study, pay-for-delay agreements are estimated to cost American consumers $3.5 billion per year, $35 billion over a decade from 2010 to 2020. Actual documentation. And so, under our current antitrust framework, a generic competitor may seek entry prior to expiration of the patents on a brand name drug by declaring that its product does not infringe the relevant patents or the relevant patents are invalid. However, given the cost and potential uncertainty of patent litigation, brand name and generic companies often settle their patent litigation before a court decision, delaying this life-saving drug. So let me just speak directly to the question of diseases and disease fights. And when I say that, the fights that certain diseases have to try and get research done, for example, at the NIH. And it particularly falls, in this instance, on people of color and in particular African Americans. So diabetes is, for example, a disease that is prevalent in minority communities, generate into all kinds of extending circumstances, limb amputation, and death, to be honest with you. Sickle cell anemia that has not had viable research done for the period of this disease, and people are still literally living and dying with sickle cell, meaning that their lifespan is cut short to 30 years old or 40 years old. MS, another disease that would welcome strong generics that could be paid for. And so if you keep these off the market, you are in a disparate manner impacting communities that suffer from these particular diseases. And I know that they generate into cancer, obviously has some of the most expensive drugs, but they generate into lives lost. So I believe that this is not only an important concept to give this authority to the FTC, but it really is the nuts and bolts of life that families are dealing with when their loved ones are deteriorating because they cannot in any way provide for or pay for these very expensive drugs. So I ask my colleagues to let our citizens save money, free up the FTC to address other issues, and increase the availability of generics in the marketplace. This bill establishes a presumption of anti-competitive behavior if a settlement agreement provides anything of value to a generic manufacturer and the agreement includes a limitation of research. Support the ability for many who suffer from these diseases to live, and support the underlying bill 2891. I yield back.
Gentlelady yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. On the amendment, nature of substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The amendments in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 2891 is amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. No. The ayes have it, and the bill is ordered reported favorably. A roll call has been, a recorded vote has been requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye.
21 right now.
Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries.
Thank you. That's amazing.
Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell.
Swalwell votes aye.
Mr. Swalwell votes aye. Mr. Liu. Mr. Raskin. Ms. Jayapal. Ms. Demmings. Ms. Demmings votes yes. Mr. Correa.
Correa votes aye.
Mr. Correa votes aye. Ms. Scanlon.
Scanlon votes aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Neguse votes aye.
Mr. Neguse votes aye. Ms. McBath.
McBath votes aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar? Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? No. Mr. Jordan votes no.
Mr. Chairman, how am I recorded?
Ms. Escobar, you are not recorded.
Escobar votes aye.
Ms. Escobar votes aye. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Isa? Mr. Isa votes no. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stube?
No.
Mr. Stube votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens?
Mr. Chairman, how am I recorded? Jayapal?
Ms. Jayapal, you are not recorded.
Jayapal votes aye.
Ms. Jayapal votes aye.
Mr. Chairman, how am I recorded?
Mr. Liu, you are not recorded.
Aye.
Mr. Liu votes aye.
Chairman, how am I recorded?
Mr. Johnson of Georgia, you are not recorded.
Johnson of Georgia votes aye.
Mr. Johnson of Georgia votes aye.
Mr. Chairman, Mr. Cohen knows he's not recorded and asked to be recorded as aye.
Mr. Cohen votes aye.
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
I'm an aye.
Mr. Jones votes aye. Mr. Deutsch votes aye.
Mr. Chairman, how am I recorded?
Mr. Roy, you are not recorded.
Aye.
Mr. Roy votes aye.
The clerk will are there any members who wish to vote who haven't voted? The clerk will report.
Mr. Chairman, there are 28 ayes and 13 noes.
The ayes have it, the bill is amended. It is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute. Incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2873, the Affordable Prescriptions for Patients through Promoting Competition Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2873, to amend the Federal Trade Commission
Without objection,
Act.
the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2873, the Affordable Prescriptions for Patients through Promoting Competition Act of 2021, is bipartisan legislation introduced by Antitrust Subcommittee Chairman Cicilline and Ranking Member Ken Buck to end an anti-competitive practice known as product hopping. Product hopping is an abusive tactic that involves making a trivial change to a product that is facing the end of patent exclusivity, such as a change to its dosage or delivery mechanism, to avoid generic competition. The pharmaceutical company then either removes the old product from the market or makes the old product seem much less attractive than the new product. Doctors and patients, therefore, have essentially no choice but to switch to the new, but not necessarily improved, prescription drug, which allows the drug maker to continue charging monopoly prices. To address these concerns, H.R. 2873 would prohibit this practice by establishing that it is an unfair method of competition in violation of the Federal Trade Commission Act. In doing so, not only would this legislation help deter such conduct in the first place through the FTC's ability to obtain equitable monetary relief, but it would also expedite traditional proceedings by providing much-needed clarity to the law. According to the Nonpartisan Congressional Budget Office, this bipartisan legislation would save American taxpayers hundreds of millions of dollars over a 10-year period. I thank Chairman Cicilline and Ranking Member Buck for their leadership on this vital legislation, and I urge all members to support it. I now recognize the Ranking Member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. The bill is not a narrow fix to a simple problem, as the proponents claim. The ways in which drugs come off patent and generics enter the market are extremely complex. If we get legislation in this area wrong, new, improved, or cheaper drugs may be held back from consumers. But to the extent this problem exists now, there are authorities already in law to fix it. The bill before us today gives new, unnecessary, and frankly unclear authorities to unelected and unaccountable regulators in the Biden administration. And we have good reason to fear these regulators will abuse their new power. Just yesterday, we heard from FTC Commissioner Wilson about the many problems at the FTC and how the chair is politicizing the commission. The text of this bill leaves too much room for Biden regulators to shape markets to fit their progressive worldview. This bill also gives the Biden FTC new expansive rulemaking authority. From what we heard yesterday in Commissioner Wilson's testimony, this new authority should give us all pause. I yield back the balance of my time.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2873, offered by Mr. Nadler of New York. Strike all after the
Without
enactment.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. The amendment in the nature of a substitute reflects a compromise reached by our Senate partners. It conforms the text of H.R. 2873 to the version of Senate 1435, which was advanced favorably by the Senate Judiciary Committee on a unanimous basis on July 29th. The first change would define a follow-on product as one that treats a condition that is identical or substantively similar to the reference product. The second change limits the Federal Trade Commission's rulemaking authority to defining any terms used in new Section 27 other than terms that are already defined. I appreciate the work of our Senate colleagues to reach agreement on this legislation, and I urge all members to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. Cicilline seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. H.R. 2873, the Affordable Prescription for Patients Through Promoting Competition Act of 2021, is a legislation that I introduced to address a clearly anti-competitive practice called product hopping, which artificially increases the price of prescription drugs. Product hopping refers to a particularly abusive tactic used by drug manufacturers to protect their profits by artificially extending their monopolies on certain prescription drugs. They do so by switching the market for a drug prior to the expiration of its patent to a newly reformulated drug with virtually no improvement or health advantage. As Professor Aaron Kesselheim of Harvard Medical School has noted, this conduct is especially problematic when the manufacturer removes the original drug from the market before its patent term expires, ensuring that generic versions of that drug cannot be marketed. In other words, this practice allows Big Pharma to preserve their profits at the expense of everyday Americans. For example, several years ago, the pharmaceutical company Actavis attempted to remove its blockbuster treatment for Alzheimer's disease and replace it with a, quote, new and improved version in order to extend its patent monopoly until 2029. The only problem? The new version was simply a once daily dosage instead of a twice daily dosage. not a significant improvement to the treatment. This is not true innovation, and it's costing hardworking Americans. Based on activists' own data, this behavior, if it had been successful, would have resulted in health insurers paying $1.4 billion more over time for the therapy. And according to a report by the Department of Health and Human Services, blocking generic entry alone would have cost American taxpayers $6 billion over a 10-year period. Americans have had enough of these games, which is why we introduced H.R. 2873, the Affordable Prescriptions for Patients Through Promoting Competition Act, together with Ranking Member Buck. H.R. 2873 will end this abusive delay tactic by expressly prohibiting product hopping as an unfair method of competition on the Federal Trade Commission Act, subject to all equitable remedies, including restitution and disgorgement of profits. I thank you, Chairman Nadler and Ranking Member Buck, as well as the sponsors of companion legislation in the Senate, Senators Blumenthal and Senator Cornyn, for their partnership on this bill. I applaud their willingness to take a strong stand against this anti-competitive conduct that puts billions of taxpayer dollars in the pockets of giant prescription drug companies that extract monopoly profits for off-patent drugs, all at the expense of our constituents, American patients. I urge all of my colleagues to support this important legislation, and I yield back the balance of my time.
Gentleman yields back. For what purpose does Mr. Buck seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, everyone's explained very well what this bill does and doesn't do. I just want to make a few additional points. And the first is that the version of the bill that we are marking up today is the version passed by voice vote in the Senate Judiciary Committee in July. Republican senators present for that vote included Senators Lee, Cruz, Hawley, and Grassley. This bill also reflects two amendments that Senator Lee offered and were accepted. Those two amendments narrowed the scope of the FTC's rulemaking authority and clarified the definition of follow-on product. Under this bill, there is no liability if a drug manufacturer can point to any legitimate business purpose other than stifling competition for why they unfairly disadvantaged their original product. This bill in no way restricts a company's ability to introduce a follow-on product. We want innovation and as many choices as possible for patients. Finally, there is no liability for introducing a follow-on product. Again, liability only arises when a drug manufacturer takes some affirmative action to disparage their own original product for the sole purpose of eliminating demand for that product and for that product. By prohibiting product hopping, more generics will enter the market, and that is a great thing for consumers. According to the Federal Trade Commission, a single generic drug competitor can significantly lower the price of a branded drug by up to 30%, while the entry of additional competitors can lower the price by 85% or more. For these reasons and the other reasons that have been explained, I urge passage of this bill, and I yield back.
Will the gentleman yield?
I will yield, yes.
I thank the gentleman for yielding. The amendment, I think, makes sense. I look forward to hearing from some of our Republican members who actually have patents and their thoughts on the amendment in the bill. But I think the amendment makes sense and would support the amendment, even though, as I expressed in my opening statement, I have reservations about the legislation. That I yield back to the gentleman.
And I yield back, Mr. Chairman.
Wait, will the chairman yield, or the gentleman yield, Mr. Buck?
The gentleman yielded back.
I guess a point of clarification, was an amendment offered? I didn't hear that.
The amendment has not been offered yet, no.
Got it, thank you, I yield back.
Okay, for what purpose does Mr. Massey seek recognition?
I move to strike the last word.
Gentleman is recognized.
This bill and the amendment to it are overly broad and deeply flawed. I'm afraid it would have a chilling effect on the development of new innovations. It's sort of like the legislative equivalent of an autoimmune disease. We are turning the FTC on the patent office. This is a hammer looking for a nail. There are problems in getting generics to market. The patent office and innovation is not one of them, but we don't control the FDA in this committee. So I guess that's why there's the temptation to use the FTC to go after innovation. I think it's harmful and will have a chilling effect. Let me tell you my story. Behind me, I have pictured the cover page of 29 of my patents. How many of those patents are original, meaning they didn't derive from any of the other patents? Only one. So I've got, of the 29 patents pictured here that I was awarded, the first one was in 1996. The title of that patent is Force Reflecting Haptic Interface. The 29th one was in 2015. The title of that patent was Force Reflecting Haptic Interface. 19 years later, was I product hopping? Was I trying to do something uncompetitive? Well, I was sure as heck trying to compete. And you do that through continuous innovation. And to make that a crime by giving the FTC overly broad authority to go after companies that innovate. By the way, in the beginning, somebody mentioned a trivial change to a drug formulation or the way that it's delivered. That might seem trivial to you, but it might be life-saving for others. It's frankly not up to the FTC to decide if an invention is new, if it's novel, non-obvious to somebody schooled in the art, or useful. That is up to the patent office to decide. And then it's up to the FDA to decide if it's efficacious and whether it's safe. And then it's up to the consumers, which are patients and doctors, to decide if the new formulation is worth the extra money over the generic. And by the way, the new formulation in no way, shape, or form, the new product in no way, shape, or form excludes the generic product from being manufactured once the original drug formulation or delivery mechanism goes off patent. There's like all these myths. There is a problem here, but it's being misidentified, and then therefore we have the wrong solution proposed. This solution would have a chilling effect. I can't imagine if I had been subject to the FTC, if I had to consider whether I submitted that patent, I got a patent 19 years later with its title of the same patent, even though I thought it was a great improvement. I can't even imagine what it would feel like to know that that would expose me to antitrust litigation, civil or criminal penalties from the FTC. And I understand that this bill targets only pharmaceutical companies, and these were not pharmaceutical inventions, although some of them were used for healthcare. It's going to having chilling effect in just that one category of innovation is going to be devastating. It'll take away the incentive for the companies to innovate, to come up with a better formulation. And then if the crime is to disparage your previous formulation or delivery mechanism because you've got a better one, that's a ridiculous thing to make a crime. If you've improved something, of course you're going to say it's new and improved and better and saves more lives and is safer and more effective than the old version, which you've abandoned because you've got a better version. And again, I don't think this is going to help anything, but I do know that it will have an effect on innovation. And it's concerning to everybody who's filed a patent, who understands how patents work, who understands that continuous innovation is just as important as that first patent, that your subsequent patents may in fact be more important than the original idea because you've been out in the field, you've tested it with patients or customers, and now you know what the better thing is to do. You've listened to their feedback and you patent the better version. And by the way, the deal that you've cut with our government that our founding fathers established in the Constitution is your product becomes public domain after exclusivity lapses. That's the case now. If there's a problem, it's not with inventors, it's with the FDA, and I yield back.
Time has expired. For what purpose does Mr. Issa seek recognition?
Mr. Chairman, to strike the last word.
Gentleman is recognized.
And in this case, to strike the same tone as the previous witness / member. Mr. Massey and I have a little difference in our patents, but a similar number of patents. And I have to be just candid. This bill bothers me, not because there isn't a problem, but because it seeks to undermine patent integrity. The basic, as Mr. Massey said accurately, what we do as patent holders to, in fact, get a patent is we show that there is a substantial difference. My understanding, it's not this committee's jurisdiction or my experience, but that the FDA also has a series of tests for whether or not, through the various phases, a drug is efficacy is sufficient to be worth granting it an FDA approval. So we have two agencies skilled, one in intellectual property, the novelness of a product, another in the efficacy of a product, both of which make a decision on behalf of the pharmaceutical companies. It begs for the question of if this hopping is being done with products that do not have any novel improvement, and in fact, their efficacy is not different, then there's two agencies that we need to reform, one of which we have complete authority over, the Patent and Trademark Office. But to bring the the FTC in begs two questions. First of all, it's not even our primary jurisdiction over that committee, even though we have antitrust. But secondly, we're giving them a test, which is to second guess the patent and to second guess the FDA. And for that reason and more, I think it's critical that if we're going to go forward with a bill like this, and I would recommend that we take it back and hold its markup for a later date till after Moore can narrow it, but it needs to be narrowed to where the actions are an antitrust actions by an entity which has market power and not the actions of a continuously improving product, which to the generic manufacturers is never that important. And yet, I'm sure the generic manufacturer doesn't want to make last year's model, but would like to have made generic next year's model. And I understand why they would do that. One of the things that I find interesting as a patent holder is that when a product is on the market, if something is so simple and obvious, the generic manufacturer, even though they are not making the product, has every ability to produce and patent a successor product. Meaning that if you see a 2-a-day drug and it's that easy and that lack of novel, then go ahead as a generic and prepare for the eventuality of the new product and make a 1-a-day version and start going through approval. But that's not what happens. So as much as I would like to support my—
Will the gentleman yield for—
in 1 second.
Okay.
I'd like to support it. We cannot do so by creating an agency that second guesses our patent system. We already have the ITC second guessing federal judges. I do not and should not believe that these patents should effectively, and I know that the standard is different, but effectively second guess the patent office. I yield to the gentleman.
Thank you. I just want to be certain that the gentleman understands this doesn't affect the patent. This is about the ability of a pharmaceutical company to pull a product from the market and prevent consumer choice by not making that first generic available. So it doesn't impact the patent. It affects the ability of the pharmaceutical company to pull it and thereby not give choice and generate monopoly profits. And according to CBO, the taxpayers and patients of this country will save $6 billion. So it's a real problem.
Reclaiming my time, I completely agree with you that that's one interpretation of the bill. But if one were to assume for a moment the alternatives based on the loose language, since the Federal Trade Commission has essentially all remedies, the remedies would clearly include, for example, prohibiting them from making the new product, even if they continue making the old product. And in order to continue producing the old product may not make sense. And I'll just give you one example. Every automobile made and sold to America or in America has one or more patents on it, many times more than one or more. And yet every year we come out with a new product and they stop making the old product. So the idea that you would not make your newer, better product, which by the way, might cost less, not more, begs the question of, if you'd like to have the Federal Trade Commission have limited remedies, then I suggest that this bill should say what those limited remedies are, and I yield back.
The gentleman yields back. For what purpose does Mr. Swallow seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you, Chairman. And I want to just go back to my colleague, Mr. Buck's concerns, because I share many of those concerns. And I want it to be clear, I support this bill's efforts to increase competition in the prescription drug market and to reduce the drug costs for patients. It's what we hear probably the most from our constituents at our town halls, probably in any district in America. But I want to be sure that this bill, particularly for my congressional district, where we have a number of biotech companies who are my constituents, who are innovators in this feel that this bill would not inadvertently limit someone's access to an improved drug product. And the example I want to give you is that, let's say someone has an illness that requires multiple injections a day. And for many of these illnesses, those injections would be painful injections, and that company would make a modification that would get rid of that pain for many of the patients. This bill, I want to make sure, would not limit a patient's access to that particular modification. And so that's just one example. There are many others. I'm not going to support the amendment if it's offered today by Mr. Buck. I appreciate the spirit that it may be offered in, but I would just yield to the chairman if he's in a position to answer. Is he willing to work with me and others to just make sure that this issue is addressed before it comes to the full floor, so that issues that significantly affect patients and modifications are addressed?
Of course.
Perfect. I'll take yes.
That's direct, simple answer.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back. For what purpose does Mr. Buck seek recognition?
Mr. Chairman, I have an amendment at the desk, and I understand that I've already lost a vote on it, but I offer the amendment now.
The clerk will report the amendment.
You're only one down.
Amendment to the amendment in the nature of a substitute offered by Mr. Buck. Beginning on page 9, line 3, insert the following.
That objection, the amendment will be considered as read, and the gentleman is recognized in support of the amendment.
I thank the chair. Mr. Chairman, there is a consensus among Republicans and Democrats that Congress must do something to lower the cost of prescription drugs for millions of Americans. It seems like everyone agrees that we should go after the bad actors who abuse our patent system and thereby prevent Americans from getting access to cheaper drugs. I think everyone, including the pharma companies, can agree that a hard switch that we have just described before is self-evidently bad behavior. In a hard switch, the drug company is essentially asking the FDA to withdraw the approved drug application and delist the drug while selling a follow-on product just to delay a generic's entry to the market. This type of gamesmanship is terrible, and I'm glad this bill makes clear that this is illegal and provides strong remedies sufficient to deter such appalling conduct. My amendment seeks to address concerns in the murkier soft switch scenario. This amendment clarifies that companies that have been sued based on a presumption of anti-competitive behavior can justify that behavior by providing evidence that the new product at issue provides a substantial improvement in safety or effectiveness, or provides a substantial benefit to patient care compared to the listed drug or reference product. Everyone's goal here is to ensure Americans can get the most effective drugs at the lowest price. By amending the soft switch justification to include this language, we make perfectly clear that companies who are acting in good faith will not be penalized. I understand some may oppose this amendment in its current form, but I respectfully request a commitment to work on this issue should the bill be reported favorably from committee today. With that, I yield back.
Mr. Gentleman yields back. For what purpose does Mr. Cicilline seek recognition?
I move to strike the last word.
Gentleman is recognized.
I first want to say, Mr. Chairman, I thank the gentleman from Colorado for his very serious attention to this important issue, and I understand his concerns. I think we all agree that Congress must do something to lower the cost of prescription drugs for hardworking Americans. I agree with the gentleman from Colorado that companies should have an opportunity to respond to allegations that they have engaged in a product hop. And in fact, the justification section of this bill, Section 3, does exactly that. This section provides ample opportunity for a company to explain its behavior and to demonstrate that it's behaving appropriately. H.R. 28730 already establishes an exception for conduct undertaken for legitimate pro-competitive reasons. Under the current exception, a drug manufacturer can justify its conduct if it can point to a legitimate business purpose other than blocking entry for why it disparaged or otherwise unfairly disadvantaged its original product. As I know, Mr. Buck knows, several amendments were offered in the Senate. 2 of them were accepted. 1 was withdrawn, the one that is currently before us. And I understand that some of my colleagues do not think the language in the bill goes far enough. However, I have serious concerns with adding language that could immunize anti-competitive conduct by a branded drug company so long as it could point to an improvement or benefit for some set of patients, no matter how small number of patients or how costly. For example, this language would potentially immunize individuals conduct with respect to Suboxone, an opioid reversal agent, which is one of the most egregious examples of product hopping. Nevertheless, I appreciate all of the bipartisan work on this bill. I look forward to continuing to work together along with our Senate sponsors to improve and strengthen the bill. And of course, I will commit to working with the gentleman from Colorado to try to address his concerns before this bill gets to the House floor.
Would the gentleman yield?
Of course.
Given the gentleman's agreement to work on this issue and the last-minute nature of the amendment, I just learned of this issue yesterday and did not have time to work with the gentleman or have the two staffs work together to try to work through this issue. I will withdraw this amendment now in recognition of the desire and good faith shown in the past to work together to try to include this language in some way that both is bipartisan and bicameral. So I thank the gentleman.
I thank the gentleman. I yield back.
I yield
The
back.
gentleman yields back. The amendment is withdrawn. Are there any other amendments to the amendment nature of a substitute? For what purpose does Mr. McClintock seek recognition?
To speak on the motion?
The gentleman is recognized.
I just want to be sure I get
Excuse me, on which motion?
on the bill.
On the bill. Good.
Thank you.
Gentleman is recognized.
I just want to be sure I understand this correctly. The problem is this. A drug gets a 12-year patent for a formula that requires 2 doses a day. 11 years into this 12-year patent, the company changes the formula so that it now only needs to be taken once a day and takes out a new patent on that. Is that the problem?
It's an example, yes, and then that patent gets extended for,
Okay, but here's my
and removes
My question.
removes the 1 dosage a day from the market, so the consumer doesn't have a choice.
So that's off the market. But a year later, that 12-year patent on the old product now expires. And any company can pick up that formula, generic manufacturer can manufacture the original 2-dose a day pill in competition. So now consumers have a choice, the lower priced generic twice-a-day pill or the higher priced once-a-day patented pill.
If the gentleman would yield?
Yeah.
Yeah, so typically what happens in that instance is the branded company, the branded drug, has been significantly disparaged, and they've killed the market for that. And so what ends up happening is the new patented drug is the one that's available that consumers
What do
have.
you mean significant?
They've disparaged it. They've said that this new one is better, it's safer, it's...
Well, isn't that up to the consumer to decide? People, every product always advertises that it's the best one available, far better than our competitors. That's called free market economics. That's
But no, but it's
free speech.
unfairly disadvantaging the consumers by
I just-
disparaging that earlier product.
You're claiming my time. I find that awfully silly. I wonder why any manufacturer would want to improve his product if he can't get a new patent for the improvement.
Because they're not improving their product. They're simply changing the dosage and then getting an extended exclusivity for its production.
But they don't have an extended exclusivity because at the end of the original patent, any generic company can pick it up, manufacture that drug, and then again, the consumer has a choice. I'd rather take 1 pill a day. But if a twice-a-day pill I can get for 1/3 the price, I'll take it twice a day. That's my choice as a consumer, not yours as a political dictator. So with that, I yield back.
Yeah,
I'll yield back.
Thank you. I might strongly suggest that
Would the gentleman from California yield? Oh,
it's not my time, but I would strongly suggest that, we are the Committee of Jurisdiction for patents. And just as we extended the length of time of a copyright, we could actually, with impunity, say that the example of changing the doses or release of a product would no longer be a patentable improvement. We could deem that that was obvious, and it would be sustained as a law. So I know that that's the favorite example, but of course it is very often not the actual improvement in the product. And so I would share with the gentleman from California that as much as I would like to see that this bill hits the target, it clearly misses the target because it goes beyond the conduct even of a hard switch, which is the example given, but that's not the only authority that's being given the Federal Trade Commission. I thank the gentleman for yielding.
And with respect to the disparagement argument, I don't know of a single product that sometime or other that doesn't say, we're better than brand X. That's product disparagement, but that's up to the consumer to make a decision. I yield to Mr. Jordan.
I thank the gentleman for yielding, and I guess I'm struck by both what the gentleman from California said and what Mr. Massey said, the gentleman from Kentucky. The ranking member, the chairman of the subcommittee said that they didn't improve the product, but they got a new patent. The patent office said it's new, novel, non-obvious, so someone said it's a better product. That's sort of the point, and we're gonna now say, no, we're not gonna allow this to happen. The FTC is gonna make that call versus the patent office, which does this all the time. And we know from the example Mr. Massey gave of his own patent, 19 years later, the same title, but a different, non-obvious, new, novel approach to something, got the patent. So I think that to me seems to be the fundamental thing here. The Democrats can say it doesn't change it, but obviously the patent office says, yes, it did. And that's why we're getting not an extension of a patent, we're getting a new patent for the new product. I yield back.
And I yield back.
The gentleman yields back. Does anyone else seek recognition?
Mr. Chairman, do I have any time? This is Massey from Kentucky.
Is it Mr.
Chairman. Mr.
No,
Chairman.
no,
Mr. Chairman.
You've spoken on this. You've spoken already.
Chairman, this is
Mr.
Chairman.
Mr. Tiffany, for what purpose is Mr. Tiffany?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
I defer to my colleague from, I believe, from Kentucky.
Thank you, Mr. Tiffany. The debate here, as Mr. Jordan and Mr. Issa and even the proponents of the bill have landed on, is whether the drug is genuinely improved. And the patent office does have the burden of deciding whether this improvement is useful, non-obvious to somebody schooled in the art, and novel. But then you've got to double check at the FDA. If the FDA says it's efficacious or useful or improved, then it would get approved by the FDA. So I don't think it makes any sense to have the FTC trying to double guess two agencies who already have the authority to determine if this is improved. So the amendment that Mr. Buck sought to offer and then withdrew intrigued me because it simultaneously solves the problem with the bill and makes the bill unnecessary if the amendment were to say that a drug company can provide as its defense to this new crime that the FTC would create, the evidence from the FDA. So for instance, Mr. Buck's amendment, and there may be something useful in there to mine and flesh out and do, his amendment provided that the drug company would have a defense if they could prove that there was an improvement. Well, why wouldn't they be able to use FDA approval as the proof or the patent approval as the proof that had been improved? It would make great sense to offer that amendment and to include it. But at that point, you realize the entire bill that's being offered today is redundant, unnecessary, and hurtful. And I'll yield back to Mr. Tiffany.
I yield to the gentleman from California.
I thank you, the gentleman, for yielding. I might add one more point that falls within the nature of international trade of patented pharmaceuticals. As many who serve on these committees know, the global standard for making a generic, even when there is a patented product, is that one of them is that product is being withheld. A country has a right, if a product is being withheld, to make its own generic. A hard switch, the abandonment, the stopping of making of a drug, even if it's in favor of a new and different drug, is in fact an abandonment, both through other committees, but through this committee. If we chose to, we could make a hard switch, a total abandonment, create an opportunity for a generic to be produced immediately. We could do that. And it would
Will the gentleman yield?
It's his time, but I will just close and he can give you his time. I think it's well within our jurisdiction, and perhaps we should consider it. But again, that would be for this hard switch, for this particular conduct of a product that many would want and might be cheaper being abandoned in favor of a more expensive one. And certainly that's what many international buyers might do. I thank the gentleman for yielding.
Who asked me to yield?
Mr. Tiffany?
I will yield for 45 seconds.
Okay, I just want to use the example that we've been using so that everyone's clear. If you had a product, for example, that was twice a day, the patent was about to run out, and they said, we have a new product, you can take it once a day. And they take off the twice a day one off the market. That new product, once a day, a generic is not available for that because it has a patent exclusivity for whatever period, 7 to 12 months. So there, to Mr. McClintock's point, someone else can't develop a one a day and compete. And the 2 a day is off the market. And so the substitution that occurs for generic can't occur because the twice a day is no longer on the market. That's why you end up with no choice. And that's why it saves $6 billion for patients and taxpayers. And thank you for yielding, Mr. Tiffany.
I yield to Mr. Issa.
The gentleman, thank you. Again, it is within our jurisdiction to determine that that conduct would be abandonment. It's within our jurisdiction to make that patent a must license or even an available at no cost. These are remedies for a particular specific action, not handing in a massive way an agency the authority effectively to second guess the patent office's decisions without even going through the procedures that we as a committee established. PTAP and Article 3 adjudication of patents is the right way to invalidate a patent as being novel or significant, not simply a five-member panel that makes a decision in order to lower cost. And I thank the gentleman for his kind yielding.
The gentleman's time has expired. For what purpose does Mr. Bishop seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2873, offered by Mr. Bishop of North Carolina, page 14, strike lines 15 through 20.
The amendment is considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. As I listened to the debate today, it has echoes a bit of what we were hearing in the antitrust subcommittee hearing, I guess it was yesterday, in which a point that was made, and it's been made before, the Affordable Care Act forced, essentially it was federal policy adopted by Congress, forced consolidation in the medical space among health insurance carriers. That led to anticipated consolidation among hospitals, physician groups, but then that became an enforcement priority of FTC, seen as anti-competitive, and so they've been after the hospitals as antagonists to this consolidation, which federal policy passed by Congress pushed. And what I'm hearing in Mr. Massey's comments, particularly Mr. Issa's, others, is that the patent law, people say, well, the patent office has granted it, and now we're going to have the FTC taking an opposite posture. It's worse than that. Congress establishes when patents are grantable. Congress says, we're going to grant you a legal monopoly. You have the right to control the field entirely and the commerce in that product. And so if the law is set such that creating a new formulation, a new aspect of the drug, or new whatever, take it one time a day versus 2 times, if the the law is such that the patent can be conferred, the legal monopoly, and now we're going to put it in the hands of another federal agency to say the doing of that which the law has granted you to exploit the monopoly in some way that you don't like is now anti-competitive.
Would the gentleman yield?
I will, Mr. Chairman.
Thank you. I'm struck by your example of hospital consolidation because it has had exactly that effect, and probably it's something we ought to deal with. The consolidation of hospitals has led to a gross lowering of wages because people have fewer potential employers, so the law of supply and demand operates, and it has led to a gross increase in medical costs for the same reason, exactly as Adam Smith
predicted. Mr. Chairman, I take your point. I'm not a fan of hospital consolidation. The point is this Congress passed Obamacare, which led to the consolidation, and then further undertakes to attack the consolidation of the hospitals that it itself created.
Well, I don't know that Obamacare led to it.
Well, I mean,
we should correct it in any event.
I don't mean to debate the point here. It's been published. Advocates for it said so.
You and I are in agreement. We should correct it in any event.
Yes, sir, I agree. But the way we correct it is not by compounding these conflicting policies that are all bred by federal policy. Fix the patent law if it's granting monopolies in a place where it shouldn't. And here's the worst part of all, and this is what this amendment does. I've still got 2 minutes. I'd submit, Mr. Cicilline, that the reason we're seeing amendments about the language when a soft hop might be okay is because the language of the statute is not entirely perfectly clear. And what you anticipate, or what I think the advocates of the bill anticipate, is that you're just going to grant a lot of power to the administrative agency. I think it's more or less arbitrary power to make its own law. So this amendment, if the bill is good as it is, if the language really is decipherable and intelligible as it is, then let it govern in the bill that you've got before you. This amendment, though, would take away the provision that grants new rulemaking authority to the FTC. Article 1, Section 8 of the Constitution gives lawmaking authority to Congress, not federal agencies. That means Congress has the ability and the obligation to develop legislation. You don't confer the power on the FTC and just assume that everything's going to be all right. I think that's what's particularly problematic, is we not only have this policy conflict that irreconcilable acts of Congress would create, but I believe the real purpose of that is to hand all this administrative power and create uncertainty in the marketplace, because you believe that's the way, the heavy hand of government and riding herd on pharmaceutical companies is the way to solve the problem. I submit, if you're confident in that, let the legislation that you're passing speak for itself. Let's take out the provision that will now allow the FTC to make its law, to decide to enforce its law, and through its administrative law judges decide the law, and through appeals to the FTC commissioners. So I think that's a pretty good summation. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Does the gentleman insist on his point of order?
I'll withdraw my point of order.
Point of order is withdrawn. For what purpose does Mr. Cicilline seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. And I appreciate the concerns of Mr. Bishop, but I rise in opposition to this amendment. It's important to note that the rulemaking provisions in this bill are very targeted and are obviously an important tool for the agency to provide additional clarity and guidance to industry. It's also important to remember that H.R. 2873 is identical to the Senate companion that was advanced by the Senate Judiciary in July with unanimous bipartisan support. And so I think, with all due respect to my good friend, Mr. Bishop, I think Senators Lee, Senator Cornyn, Senator Cruz, Senator Hawley, Senator Tillis, Senator Grassley, who all support this bill, would be surprised to be described as individuals who are supporting grabbing a lot of power by an administrative agency. The amendment, in the nature of a substitute, already reflects the compromise that was reached by our Senate partners to address the goals of this amendment. It limits the FTC's rulemaking authority to defining terms not already defined in the bill. And out of our deference to our Senate partners and the bipartisan, bicameral nature of this, I urge members of this committee to reject this amendment so that we can move forward in a serious way to stop these anti-competitive practices that are gouging our constituents in the cost of prescription drugs. And with that, I yield back.
Would the gentleman yield?
Oh, certainly. I'm happy to yield to Mr. Buck.
I just want to make one clarification. While Senator Lee supported the bill out of committee, he did put a hold on this bill in the Senate based on the amendment that I offered earlier that you and I have agreed to work on. So I don't want to mislead anybody in terms of there are a number of Republican senators who are in favor of this bill. However, Senator Lee still has a reservation that we hope to address.
Are you just trying to strengthen your hand in our negotiations, Mr. Buck? Duly noted. I yield back.
Gentleman yields back.
Mr. Chairman?
For our purposes, Mr. Liu seek recognition.
I move to strike the last word.
Gentleman is recognized.
I have a question about how this bill operates, and if we use that same example that Representative Cicilline used? And if the author, if you could answer my question, that'd be great. So let's say you had a drug manufacturer that had a 2-a-day formulation for a drug. Then they switch to a 1-a-day. If they don't take the 2-a-day off the market, what does this bill do? And in that case, and I guess my question is, isn't the real problem the fact that the patent office granted a patent of a bunch more years for the 1-a-day formulation? And why don't we fix that problem instead? So that's my second question.
Yeah, I mean, I think if the gentleman will yield, I'm happy to. I think
Yes, I yield.
I think there are obviously ways to approach this problem that may involve some reforms of the patent office. I haven't studied that to know whether that's another way to address this problem. But in the problem that in the example you give, if they don't remove that choice of the other dosage from the market, that's a soft switch. And so long as there was a reason they can justify for that that's set forth in the statute, it's fine. It's when they remove that other option, that there's no longer a consumer choice, and then the generic substitution can't occur because that other product is not in the market. That's where the harm comes.
I reclaim my time, and I'm going to ask one more question. So under a soft switch, what would this bill do? And I yield to the author of the bill.
So, on this, the bill doesn't contain any restrictions on a drug manufacturer's ability to introduce a follow-on product. The only conduct that is prohibited under this bill is when a drug manufacturer does something to the original product that unfairly disadvantages it by destroying the inventory, increasing the price, spreading false warnings about safety concerns or otherwise, so disparaging that product. That's the action that's prohibited.
Would the gentleman yield?
Yes.
I assume the gentleman means when the drug company makes that change, and that change has no benefit, doesn't in fact change the pharmaceutical benefit, but it simply gives the drug company the ability to increase the price.
Yes.
I yield back.
Reclaiming my time, I appreciate those answers. I yield back.
Gentleman yields back. For what purpose does Mr. Massey seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
I support Mr. Bishop's amendment. He is correct. We have the lawmaking authority in Congress. If we think there's a problem here and we think we know the solution, then we are obligated to put the answer in legislation as a law instead of punting some vague authority to some administrative organization. I love this example of a drug that's made 2 times per day and then somehow trying to prosecute somebody for if they try to come out with a better version that you only have to take 1 time per day. It's a great example. Let's think through it.
Would the gentleman yield?
Let me finish my thought, then I'll yield to you. Because I would love for somebody on the other side to answer this, and maybe the chairman can answer this question. What is the obvious effect if we threaten to litigate a company for innovating and abandoning their lesser product for the better product? What is that company going to do once they're faced with litigation if they come out with a better product and abandon the old product before the expiration of their rights under the patent law? I now yield to the chairman.
Thank you. The whole point is that it is not a better product. It has no pharmaceutical benefit over the old product. It's simply a change from 2 a day or to 1 a day, or vice versa. It doesn't matter. That gets the change gets it a new patent, but it means.
Yeah, my video is stopped. Can y'all put me back
But
on?
someone should mute the microphone. It may be an improvement for some small set of patients, but it doesn't justify the fact that that they can get a huge price increase when there's no substantial benefit. It does go to the FTC, not because we don't have to make laws to change that. The FTC has the rulemaking authority, and that's why the FTC exists. I yield back.
Reclaiming my time possibly for another question, does the chairman believe that the Patent Office and the FDA are unequipped to make these decisions about improvements, and that the FTC, which is involved in regulating business trade practices, that they would somehow be more knowledgeable on the efficacy of a drug or the novelty of an invention than the Patent Office and the FDA?
The FTC is the expert on anti-competitive conduct, and that's why the bill directs it there, because they're set up for that purpose.
Well, if the chairman, reclaiming my time, patents are the definition of anti-competitive. In the short term, you're granted a monopoly, you're granted exclusivity. So to take the FTC and turn it on the Patent Office, I believe it's like an autoimmune disease. This is it's the body attacking itself. It makes no sense to do that. And by the way, there's no guarantee that the price goes down on the product. Let's say you're 15 years into your 20-year patent and you've got 2 times a day product, and you just discovered, by the way, after millions of dollars of research and testing, that you can do it 1 time per day. And it does provide a marginal benefit. But if you know that you're going to be pursued by the FTC, even though the FDA has said you have a better product, if you know you're going to be pursued by the FTC for offering that product and abandoning the old product, or even just selling them at the same price,
Gentleman yield?
Then you would be disincentivized from doing it. By the way, it's not generally the manufacturer, it's the generic that lowers the price. There's an assumption here that the original manufacturer would all of a sudden have a product that's 10 times lower when they came out with the better one. That's not the case. I will yield to the chairman.
Thank you. That's why the focus of this bill is on the anti-competitive conduct. Whether the branded drug company unfairly disadvantaged its own original product relative to the follow-on during the limited competition window. The bill provides that such conduct is presumptively illegal because there's often no other justification other than blocking competition for a company to take actions that disadvantage or handicap its own successful product. In other words,
reclaiming my time, would it be illegal to say that your new product is better than the old product? If the FDA has said that it is?
No, it would not be illegal.
Shouldn't that be a safe harbor? The FDA should be evidence that you have a better product and therefore should be immune. I see my time has expired.
Let me just say, it is spreading information.
Your time has expired.
The gentleman's time has in fact expired. For what purpose does Mr. Tiffany seek recognition?
Move to strike the last word.
Gentleman is recognized.
I defer to the gentleman from North Carolina.
I thank Mr. Tiffany. To the point that was just being asked by Mr. Massey, he said, if the manufacturer, the patent holder, said our product's better than the old product, would that be wrongful? Well, look at how this bill defines what a soft switch is. It's if the manufacturer engaged in both of the following actions. The manufacturer took actions with respect to the listed drug or referenced product other than those described in subparagraph A, so it's not a hard switch, that unfairly disadvantage the listed drug or referenced product relative to the follow-on product in a manner that impedes competition from a generic drug or a biosimilar product which may be established by objective circumstances, and the manufacturer marketed or sold a follow-on product. Why wouldn't that include saying our new product is better? What does unfairly mean? Unfairly disadvantage the listed drug or reference product. And to the point of the amendment that is before us, who gets to decide what that means? Because I have no clue what that means, reading it as an ordinary person, reading language at first pass. That's up to Lena Khan. You're not even establishing clear polar opposites in the law, which would be bad enough that at least someone could try to sail between, granting monopoly of power through a patent on one hand, and on the other hand saying you can't exercise your monopoly power through a patent. See, but you're not only getting 2 clear pictures. On the latter, what you're getting is you better check with the FTC and we're going to grant them the power to make law. and they can make it any way they want to. All they got to do is fit within that language, which is about as vague as anything I could imagine. And why and how the chairman, and I'd yield to the chairman, if you can say how saying our subsequent product is better would not unfairly disadvantage. I think the chairman's argument earlier would be, or Mr. Cicilline's, well, that doesn't really, the fact that you can take it once a day is no better. But a consumer might well disagree with that. And so I imagine there'd be a disagreement over that, and who gets to resolve it? A bureaucrat. And I yield back to Mr. Tiffany.
Mr. Tiffany. Okay, thank you. That's the thing that I find kind of curious here is it seems we're leaving the consumer out of this. I listened to the example from the chairman in regards to this, that whether it's 2 a day or 1 a day, that the bureaucracy should be making this decision. Where does the consumer come into this? Why are we leaving them out of it? I yield to the gentleman from Kentucky.
Thank you, Mr. Tiffany, for being so generous with your time. Again, let's hammer this 2 times per day back to 1 time per day. Since the bill's author and the chairman are using that as an example, I presume they're saying that's a crime. That somebody who's claiming that you take a drug 1 time per day, that makes it a better drug than you have to take the same drug 2 times per day. You're saying that would be a crime that the FTC could pursue or litigate because they've made a claim that's not true, because they've said their drug is better if you take it 1 time per day instead of 2 times per day. Is that the specific example that you're saying would be prosecuted? And I'll yield to the chairman.
If the gentleman would yield, yeah.
Yes.
I've said this, I'll just repeat it again. Maybe it's because you're on audio and not here in person, but I'll say it again. The only conduct that is prohibited is when a drug manufacturer does something to the original product that unfairly disadvantages, that is, destroys inventory, increases the price, spreads false warnings about safety concerns or otherwise. An add-on product that's an improvement is not barred, period. And that's
So
the amendment that is before us is about taking away the authority of the FTC to make rules, and I'm happy to engage with Mr.
By the way,
Bishop on the
gentlemen,
amendment.
this is my time that
reclaim
you're
your-
using. I yield to
I thought you
Mr.
yielded to
Massey.
me.
Thank you, Mr. Tiffany. Look, you're seeking to make a new crime here, and you're using this specific example that a drug company is abusing their market position if they come out with the drug that's 1 time per day instead of 2 times per day, and they drop the 2 time per day drug. You're trying to tell us that should be a crime or something that should be litigated against that company. Is that the best example you have? Because I think that's an improvement for an Alzheimer's patient. If your problem is remembering to take the drug and you can take it 1 time per day instead of 2 times per day, that seems like an obvious improvement to me. But you want to make it criminal to drop or litigate.
The gentleman's time has expired. Are there any further, for what purpose does Mr. Issa seek recognition?
I move to strike the last word.
Gentleman's recognized.
Mr. Chairman, I think you had a question.
I just wanted to you yield to me.
Yes, sir.
I thank you. I just wanted to point out that Mr. Massey is making a wrong assumption. Nobody is talking about a crime. This bill has nothing to do with criminal law. It is not making anything a crime. So forget the crime business. All this bill does is protect the public against a manufacturer who, by getting a new patent on something that really is no improvement, the efficacy of the drug pharmaceutically is the same, but he gets a patent because it's 1 pill a day instead of 2 pills a day, or vice versa, and he gets a patent and thus can stave off generic competition. This bill says he can't do that, that it wouldn't stave off the generic competition, and that's why it would save the consumers a lot of money. I think Mrs. Cicilline said $6 billion a year, but it has nothing to do with the crime.
I thank the gentleman in reclaiming my time. Mr. Tiffany, did you need any time?
I just want a couple seconds.
I do. Of course.
If I may, please. Thank you very much. I think this gets to the heart of the issue. I brought up consumers earlier. We are deciding, or we're giving this authority to the FTC. They get to decide how a consumer is supposed to value something like this. I mean, think about that. When you say let's say you take this pill or you take this injection 2 times a day or 1 time a day, and you're able to do it once a day rather than twice a day, how do you know how a consumer's going to value that? They may put enormous value. They may put very little value on it. They may put enormous value. They may say, this is something that is really worthwhile to me. And I think that's what we're injecting ourselves into. I yield back.
Thank you. And reclaiming my time, I know we've been using 2 times a day versus 1 time a day, but many times before this in other committees, someone I consider a friend and somewhat of a mentor, Dean Kamen, has sat here and talked to us. Now, one of his products, one of his thousands of inventions and products and ideas was the insulin pump.
There you go.
Amazing. You know, look, insulin can be taken in it can be taken orally. In some cases, it can be taken by shots. But the people who take it, of course, would tell you that the more often it is injected, the more accurately it's injected, makes a huge difference, sometimes life and death differences to them. Just a second, Mr. Chairman. And so he was granted a patent. I realize it wasn't necessarily the only patent, but if he were granted a patent on the pump doing it twice as often and the pump doing it more accurately, and then again, each of those could be life savings and hugely valuable. And he would certainly abandon the earlier product immediately in favor of the product that was for both life and safety and people's benefit better. So I do think that this is a meaningful discussion. I think it goes to the basic core question of, if the patent office makes these determinations, are we the committee that is going to split that jurisdiction away from the patent office? And I might reiterate what I said earlier in an earlier amendment. We have the ability to change the PTAB process. We have the ability to change the examiner's consideration or even what is patentable. With all that authority, we could certainly deal with Mr. Cicilline's examples by dealing with it in underlying patents. And another committee could deal with it based on the the FDA's approval process. But I strongly agree with the gentleman from North Carolina, who I'll also yield to, that we need to seriously consider whether or not we're going to create an additional entity. And I'd yield 30 seconds to the gentleman from North Carolina.
I thank the gentleman from California. And, if I could pose a question, I can't in the current posture to Mr. Cicilline. He keeps repeating that this is no issue unless the reference product, the original product, is taken off the market. That is what a hard hop is. But a soft hop, it's like you're reading subparagraph B out of the section. Subparagraph B makes it an unfair method of competition affecting commerce in violation of Section 5 of the Act to do a soft hop if those criteria apply that I've previously read from that are unintelligible. And I yield back to the gentleman from California.
Thank you. And with that, I think the gentleman's satisfied that there's a lot more work to be done on this bill. A lot more amendments need to be considered, and perhaps even the underlying premise of the bill needs to be reconsidered. And with that, I yield back.
Gentleman yields back. For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chairman, I have a unanimous consent request.
The gentleman will state his unanimous consent request.
Mr. Chairman, I ask that a unanimous consent that a report entitled "The Cost of Brand Drug Product Hopping," which reads in part, "This report looks at just 5 examples of this tactic over the last 20 years for the brand drugs Prilosec, Tricor, Suboxone, Dorex, Namenia, and estimates that these 5 products hops carried a total cost of $4.7 billion annually." And I also ask unanimous consent that an analysis by Michael Carey, the distinguished professor of law at Rogers Law School, that references empirical analysis found $28 billion worth of drugs subject to product hopping, including Adavir, Allegra, Augmentin, Caudex, Clarinex, Cabodex, Lexapro, Nexium, Prozac, Risperdal. And I ask that this be part of the record. And for those who are wondering, is anyone getting harmed and who are standing up for?
Without objection. The question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no? No?
No.
In the opinion of the chair, the noes have it. Roll call is asked for. The clerk will call the roll.
Mr. Nadler,
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen?
Hi, Mark. How are you? This is
Mr.
Karen
Johnson of
Bass.
Georgia?
Someone has got to mute themselves.
Johnson of Georgia votes no.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries?
I'd like to vote aye. Can you hear me? Cohen votes aye.
Mr. Cohen
Cohen
votes
votes
aye.
aye.
Someone has to mute themselves. Someone has to mute themselves.
Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
Nope.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Demmings?
No.
Ms. Demmings votes no. Mr. Correa? Ms. Scanlon?
Scanlon votes no.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Mr. Gomer votes aye.
Mr. Gomert votes aye. Mr. Isa? Mr. Isa votes aye. Mr. Buck? Mr. Buck votes no. Mr. Gates?
No.
Mr. Johnson
Hello?
of Louisiana?
How am I recorded?
Mr. Correa, you are not recorded. Mr. Correa, you're not recorded.
Maria votes no.
Mr. Correa votes no.
How am I recorded? Mr. Cohen, how am I recorded? Mr. Cohen recorded?
How am I recorded?
Mr. Cohen, you are not, Mr. Cohen, you are recorded as aye.
I want to be no.
Mr. Cohen votes
I
no.
want to be no.
How is Raskin recorded?
Mr. Raskin, you are not recorded.
Raskin votes no.
Mr. Raskin votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Owens? Mr. Owens votes no.
Mr. Chairman, how am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Mr. Chairman, how am I recorded?
Mr. Jones, you are not recorded.
No.
Mr. Jones votes no.
Are there any members who wish to be recorded who haven't been recorded? The clerk will report.
Mr. Chairman, there are 15 ayes and 26 noes.
The amendment is not agreed to. For what purpose does Mr. Fitzgerald seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2873, offered by Mr. Fitzgerald of Wisconsin, page 14, line 20.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Mr. Chairman, the FTC's blatant power grab has had a chilling effect on businesses and our economy at a time we are struggling to recover from the pandemic. This agency has shifted from a bipartisan agency that protects consumer protection in an agency at the mercy of a chair bent on merging big business with big government. If a statute must be interpreted, the federal courts are the appropriate constitutional branch to decide what the law says, as explained in the Supreme Court's holding in Marbury versus Madison. In 1984, the Supreme Court held in Chevron versus Natural Resources Defense Council that in interpreting an ambiguous statute, courts should defer to the agency's answer or interpretation if that interpretation is not unreasonable, so long as Congress has not spoken directly to the precise issue at question. This ruling became known as the two-part test known as Chevron deference, leaving government agencies with considerable power in court. My amendment would simply exempt rulemaking under this bill from Chevron deference. I urge my colleagues to support this amendment to rein in the agency run amok, and I yield back.
Mr. Chairman.
And it's the gentleman's time.
He yielded back.
Oh,
I
he
yield
yielded
back. I
back.
yield back, Mr. Chairman.
I just want to withdraw my point of order, Mr. Chairman.
Point of order is withdrawn. I'll recognize myself in opposition to the amendment. The FTC rulemaking provision in this bill is a targeted and important tool for the agency to provide additional clarity and guidance to industry. H.R. 2873 is identical to the Senate companion that was advanced by the Senate Judiciary in July with unanimous bipartisan support. The amendment nature of a substitute already reflects the compromise reached by our Senate partners to address the goals of this amendment. H.R. 2873 limits the FTC's rulemaking authority to defining terms not already defined in the bill. Out of deference to our Senate partners who are unable to accept this amendment, I would also point out that this amendment is substantively the same as the amendment we just defeated a moment ago. It would have exactly the same effect. And I therefore oppose the amendment. And I yield back. For what purpose does Mr. Liu seek recognition?
Move to strike to the last word.
Gentleman is recognized.
So I want to again thank Congressman Cicilline and all the other co-sponsors of this bill. I completely understand that product hopping is bad. We have to mitigate it. I'm just trying to understand how this bill works, because when I read the text, it doesn't seem to work the way that I thought it worked or the way it's been represented. So I'm talking about the soft switch example, where let's say a drug manufacturer goes from a 2-a-day formulation to a 1-a-day, but doesn't take the 2-a-day off the market. Under that example, as I read this bill on page 7, the standard that applies is if the manufacturer unfairly disadvantaged the 2-a-day drug in a manner that impedes competition from a generic drug. So as I read that, that's basically the only standard. To me, that would mean if the manufacturer came out with a 1-a-day drug and said, hey, 1-a-day drug is better because you only take it 1 a day instead of having to remember to take it twice a day, that would be prohibited under this bill. I don't see anything under the soft switch about destroying inventory or all those bad things.
Gentleman yield.
And so unless I'm not reading this correctly, I don't know if I can vote for this bill as it's written. And with that, I will yield to whoever can answer that question.
Well, the bill unless it disparages the old drug, that's fine. If it disparages the old drug, that's misleading the public, and it's not fine, and that's all this bill would do.
I reclaim my time. That's not what the text of the bill says. I'm just reading page 7. It has to, basically, it says in a manner that impedes competition from a generic drug. And so if I'm a drug manufacturer, and it seems like if I say the 1 a day is better than a 2 a day, I'm going to be impeding competition because I'm saying buy the 1 a day because it's better.
Yeah, well, if you look on page 7 of the bill, you see it says exclusions. Nothing in this section shall prohibit actions that consist solely of truthful, non-misleading promotional marketing or ceasing promotional marketing for the listed drug or reference product. So that should answer your question.
Reclaim my time. Thank you, Mr. Chairman, for the answer. I'll continue to review the text.
Would the gentleman yield further?
Yes, I'll yield.
Thank you. Thank my California colleague. You know, we used an example earlier. Maybe it's good to use it again. If you and I each had a Ford F-150 and next year's model comes out, what is it that Ford does with the new F-150 that has an aluminum bed? It tells you how much better it is. It ceases making the old model with the steel bed, and it, quite frankly, to a certain extent, disparages its own product in favor of the newer product, and it clearly wholesales out the old ones and doesn't make them anymore. The process of having a new, better product that happens to enjoy a patent is no different than what every company does with its own successor products. And so I think the gentleman is exactly right that the conduct that they're saying is wrong might in fact be ordinary, routine, and appropriate, and under the current reasonable interpretation of the text that you're reading, this could lead to the Federal Trade Commission pursuing companies which would cost them a fortune, and they may or may not prevail in court.
Would the gentleman yield?
I'm happy to yield.
Thank you, Mr. Liu. I disagree with my friend from California's comments, and that in the example of the F-150, nothing that Ford said about its new product was untruthful or misleading in terms of its promotion or marketing. It was a truthful and accurate statement to say that the new product was a better product. There's nothing in this statute that prohibits a company from discussing the advantages of the 1 a day over the 2 a day. So in this situation, there would be nothing that the FTC could do or should do about the new product. What this statute intends to cover are lies, and it gives the FTC the ability to go after a drug manufacturer when they lie about the old product to try to get the consumers to buy the more expensive new product and not the old product when it goes to a generic. That's the intent of this statute, I believe.
I think, gentleman's time has expired.
Move to strike the last word.
What purpose does Mr. Bishop seek recognition?
To strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I wonder, Mr. Buck, if you would point out to me the language. It's on page 7. It would have to be on page 7. The language that says that the wrong would be a lie about the former
I'd be glad
reference
to.
product.
Would the gentleman yield?
I want to yield for that purpose. Yes, sir.
Yeah, absolutely. Subsection 2, exclusions. Nothing in this section shall prohibit actions that consist solely of truthful promotional statements. Now, truthful is the opposite of lie. So if nothing is prohibited that is truthful, then lies are prohibited.
What does it mean to unfairly disadvantage the listed product?
Well, go down to section 2 and look for the definition. What
Are you saying
unfairly
that-
disadvantages is when you lie.
Are you saying that the language that unfairly disadvantaged the listed drug or reference product, followed by the language you refer to in the exclusion, could you have easily have said that as saying that it would be that if that one lies about the listed drug? I mean, why not just say that more simply?
You know what? I don't know. You and I both got law degrees so that we could charge money to people that don't want to pay for simple language. And I would suggest to you that this is going to keep lawyers in business for a long, long time.
Yeah, but the objective here, you would agree with me, Mr. Buck, is to get the language so that it's understandable.
And
If you,
absolutely.
and any judge who reads this is certainly going to read the language that says it's a soft hop. If you do something that unfairly disadvantages a listed product, drug, or reference product, or proceed in a manner that impedes competition from a generic drug or biosimilar biological product, which may be established by objective circumstances, and only have an exclusion down below that talks about nothing prohibits truthful, non-misleading promotional marketing. It leaves in other words, if what you say is true, that what this is driving at or what this seeks to do is to prevent lies, then say it in 5 words instead of saying it in a paragraph and a half. That leaves open the question, what is all that language for? Any Article III judge reading this language can recognize that you mean something other than that straightforward statement.
I don't think that's true. You were reading 9 lines there. My friend from North Carolina would have to read 9 lines, and most Article III judges can read 9 lines of text and understand that the definition of unfairly disadvantaged means untruthful statements.
Not to pick a nit, but it's 14 lines. It is 2 paragraphs, the second paragraph of which is broken into 3 subparagraphs. It's quite a lot.
Okay.
And if it were just a matter of, and I yield to the gentleman from California.
I think, this gentleman, right? Okay, there's several gentlemen from California. Some years ago, early in my time here, there was a court decision that invalidated a patent because the patent, it happened to be a pharmaceutical patent, and it happened to be on a time-release drug because they claimed that it was a significant and substantial improvement. Now, the Fed Circuit overturned the Article III judge, who I guess could read somewhere between 7 and 14 lines, by saying that, in fact, bragging about your product was okay, and that a patent that claimed significant or pioneering and so on was ordinary and routine. And that case was significant to me because I was astounded that a district judge would find that bragging about your product or saying that something you did was significant would in fact invalidate a patent as wrong. So we have a case in point. It happens to be Purdue. It happens to be the OxyContin case. But when they, for a short time, lost their patent. So I'm not talking about the product, but I am talking about the principle. Yes, Article III judges can get it wrong, and there, but for the Fed Circuit, would have gotten it right. This legislation actually codifies what that judge got wrong that the Federal Circuit had to overturn, which is you better believe you should be able to claim that your product is better, significantly better, safer, and even if that is not absolutely provable to the nth degree, it still should not invalidate your claim and cause you to, in fact, be found by the Federal Trade Commission to be an antitrust violator. And yet that's what this bill would do in its current form. I thank the gentleman for yielding.
I thank the gentleman, and I look around to see if anybody else wants to speak, and seeing none, I yield back.
Gentleman yields back.
Mr.
For
Chairman.
what purpose is anyone seeking recognition?
Congressman Massey from Kentucky.
For what purpose is the gentleman seeking recognition?
Move to strike the last word.
Gentleman's recognized.
I support the Fitzgerald Amendment. I don't need to say much about this other than this amendment should be attached to every piece of legislation that leaves this body and goes to the president for his signature. And I yield back the balance of my time.
Gentleman yields back. The question occurs on the amendment. All in favor say aye. Aye. Opposed,
Aye.
no.
No.
No. In the opinion of the chair, the noes have it.
Mr. Chairman, the yeas and nays.
The yeas and nays are requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no.
Someone should mute themselves.
No.
Mr. Cohen
Cohen,
votes
no.
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass?
Bass votes no.
Ms. Bass votes no. Mr. Jeffries?
Jeffries votes no.
Mr. Jeffries votes no. Mr. Cicilline? Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin?
I am the other representative.
Ms. Jayapal?
No.
Ms. Jayapal votes
Someone
no.
should mute themselves again.
Ms. Demmings? Ms. Demmings votes no. Mr. Correa? Ms. Scanlon?
Scanlon votes no.
Ms. Scanlon votes no. Ms. Garcia?
Garcia votes no.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush
How
votes
is
no.
Swalwell recorded?
Mr. Swalwell, you are not recorded.
Nope.
Mr. Swalwell votes no. Mr. Jordan?
How is Mr. Correa recorded?
Mr. Correa, you are not recorded. Mr. Correa, you'll have to unmute yourself.
Correa votes no.
Mr. Correa votes no. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye.
The difference.
Mr. Gomert?
Okay, it's 10% down. I'm gonna have to,
Mr. Isom?
I wonder if there's
Mr.
a
Isom
longer.
votes aye.
Someone has
There
to
a-
mute themselves
thing
again.
that This goes over here. They got to push it over.
Mr.
Chairman,
Buck?
how am I recorded?
Is there a better way to?
Mr. Jones, you are not recorded.
Handbooks. Isn't there
I
some kind
vote
of,
no.
you can.
Mr.
do this
Jones
with?
votes no. Mr.
Yeah, I mean,
Buck?
it seems like there would be. I can't imagine there isn't.
Mr. Gates?
I want to remind members they should mute themselves.
Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Owens? Mr. Owens votes aye.
Mr. Chairman, how am I recorded? It's Raskin.
Mr. Raskin? You are not recorded.
Raskin votes no.
Mr. Raskin votes no.
Are we ready for that?
Mr. Chairman, how am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Mr. Chairman, how am I recorded?
Mr. Johnson of Georgia, you are not recorded.
Vote no.
Mr. Johnson of Georgia votes no.
Have all members who wish to vote voted?
Mr. Chairman, how am I recorded?
Ms. Escobar, you are recorded as no.
Okay, great, thank you.
How is Massey recorded?
Mr. Massey, you are recorded as aye.
Should say how am I recorded?
Madam Clerk, how am I recorded?
Mr. Cicilline, you are not recorded.
No.
Mr. Cicilline votes no.
Was Jayapal recorded? Sorry, I think I was.
Ms. Jayapal, you are recorded as no.
Thank you.
Have all members who wish to be recorded been recorded? The clerk will report.
Mr. Chairman, there are 15 ayes and 25 noes.
The amendment is not agreed to. For what purpose does Mr. Massey seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2873, offered by Mr. Massey of Kentucky. Beginning on page 9, line 3, insert the following.
Chairman. Positions at the
Without-
upper level.
Without objection, the amendment
More
will be
critically, at the
considered.
entry level, you know.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Surrounds education, the future of education. Are we going
Again, all
to
members should
supply
mute
2
themselves.
years of free community college?
All members should
I
mute themselves.
personally, forget about the politics of that.
Mr. Chairman, am I
Yeah.
recognized?
You are recognized.
Thank you, Mr. Chairman. This amendment is the result of a lot of R&D. I don't mean research and development, I mean ripoff and duplication. I've taken Mr. Buck's excellent amendment, which and duplicated it, and Mr. Buck has taken Senator Lee's amendment to come up with his amendment, which I have duplicated. So after much R&D, I offer the same amendment that Mr. Buck offered. I cannot support the underlying bill in any circumstance, but we were told earlier that, or led to believe that Senator Lee's amendment offered by Mr. Buck and now offered by me would possibly make it into this legislation before it made it to the floor. And if anybody believes that, I've got a bridge to sell you. Of course, this deserves a vote in our committee. We don't want to leave it to chance. And so without speaking much further, I'll just say this amendment is a good idea for all the reasons that Mr. Buck thinks or thought it was a good idea when he offered it. And I yield back.
The gentleman yields back. Point of order is withdrawn. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, we've already debated this amendment. I would just remind my colleagues that the justification section of this bill, section 3, provides an opportunity for companies to assert the claim that the amendment intends to develop. This section provides ample opportunity for a company to explain its behavior and demonstrate that it's behaving appropriately. It establishes an exception for conduct undertaken for legitimate pro-competitive reasons. And under the current exception, a drug manufacturer can justify its conduct if it can point to a legitimate business purpose other than blocking entry for why it disparaged or otherwise unfairly disadvantaged its original product. And so again, as I indicated, this was withdrawn in the Senate, and so we are attempting to keep our bill the same as the Senate version, with obviously a commitment to continue to work on this and any other issues, both with our colleagues in the Senate and with members of this committee before the bill comes to the House floor. And as a consequence, I ask that we reject this amendment, and I yield back, Mr. Chairman.
Gentleman yields back.
Would somebody yield time to me?
Who else seeks
30 seconds.
recognition?
Mr. Chairman,
I do.
What purpose does Mr. Jordan seek recognition?
yield to the gentleman from Kentucky.
Gentleman yields.
I thank the ranking member from Ohio. I just want to add that it's my belief that any reports from the FDA regarding the efficacy or the improvement of the advanced drug that is newly patented should serve as proof that under this amendment that the follow-on product has been substantially improved. In other words, if the FDA believes that the product has been substantially improved in its safety or effectiveness, or provides a substantial benefit to patient care compared to the listed drug or reference product, then that should serve as proof under this amendment as well. I just wanted to give a specific example of how this amendment could work. And I yield back to the gentleman from Ohio.
I yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. All those in favor say aye.
Aye.
Opposed, no. No.
No.
In the opinion of the chair, the noes have it.
Mr. Chairman, I seek a recorded vote.
Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen?
No.
Mr. Cohen votes no. Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
No.
Mr. Deutsch votes no. Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Demmings? Ms. Demmings votes no. Mr. Correa? Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
My concern.
Ms. Dean votes no. Ms.
PMPNF.
Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr.
Bush votes
Jordan?
no. Bush
How
votes
is Swalwell recorded?
Mr. Swalwell, you are not recorded.
No.
Mr. Swalwell votes no.
How is Raskin reported?
Mr. Raskin, you are not recorded.
Raskin votes no.
Mr. Raskin votes no.
how am I recorded?
Ms. Bush, you are not recorded.
Bush votes no.
Ms. Bush votes no. Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Shabbat?
I'm voting yes, but I would note that generally members asking to be recorded wait until the entire roll on both Republicans and Democrats has been called before you come back and ask how you're recorded. But that's the tradition. I don't know if we're going to follow that or not. Yield back.
Mr. Shabbat votes yes. Mr. Gomert?
Mr. Gomer votes yes.
Mr. Gomert votes yes. Mr. Isa?
I second the gentleman's belief that that's the right way to do it and vote yes.
Mr. Isa votes yes. Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Massey votes aye, and I would like to reiterate Mr. Shabbat's desire that we complete voting before the Democrats start a second round of voting. Thank you.
Mr. Massey votes aye. Mr. Roy?
Aye. Co-sponsor of the sentiments.
Mr. Roy votes aye. Mr. Bishop? Aye. Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Bentz votes yes. Mr. Owens? Mr. Owens votes aye.
Are there any other members who wish to be recorded who haven't been recorded?
Mr. Chairman, how is Congressman Correa recorded?
Mr. Correa, you are not recorded.
Correa votes no.
Mr. Correa votes no.
Are there any other members who wish to be recorded? The clerk will report.
Mr. Chairman, there are 16 ayes and 23 noes.
The amendment is not agreed to. Are there any other amendments?
Mr. Chairman, I have an amendment at the desk.
Gentlemen, for what purpose does Mr. Fitzgerald seek recognition?
I have an amendment at the desk, Mr. Chairman.
Mr. Chairman, I reserve a point of order.
Clerk will report the amendment. Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 2873, offered by Mr. Fitzgerald of Wisconsin. Page 2, line 25, strike "and" at the end.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. I have an amendment, Mr. Chairman, product hopping is an anti-competitive practice that unfairly extends the life of a drug that is losing market exclusivity. One of the best ways to lower drug prices and encourage generic options. However, I have concerns that this bill as written sets too expansive a definition of a follow-on product. My amendment would simply add 2 additional exclusions to the definition. One for a product where the FDA is granted new chemical entity exclusivity, and another for exclusivity granted by the FDA under the Public Health Service Act. This language is identical to the language that passed this committee on a bipartisan basis last Congress. I urge my colleagues to support this common sense amendment to prevent patent abuse while encouraging innovation. I yield back.
Gentleman yields back. Does the gentlelady insist on does the gentleman insist on his point of order?
No, Mr. Chairman, I withdraw my point of order.
Point of order is withdrawn. For what purpose does the gentleman for Rhode Island seek recognition?
Move to strike the last word.
Gentleman is recognized.
I rise in opposition to the amendment. The new chemical entity, or NCE, exclusion was added to the bill last Congress as part of a sincere effort to work on a bipartisan basis to exclude situations that would not constitute an anti-competitive product hop. The Senate version never had this NCE exclusion. Since then, the Federal Trade Commission and others have expressed concerns with this exception, cautioning that it would create a sizable loophole such that the bill would be worse than current law. In light of this feedback, as well as the opposition to including it from our Senate counterparts, we strongly oppose any efforts to include it. Furthermore, this bill contains 0 restrictions on a drug manufacturer's ability to introduce a follow-on product. The only conduct that is prohibited is when a drug manufacturer does something to the original product that unfairly disadvantages it by destroying inventory, increasing the price, spreading false warnings about safety concerns or otherwise. And again, in the spirit of keeping this bill in the same version of our Senate colleagues, and because there was recognition that this inclusion would create a sizable loophole, making it worse than current law, I strongly urge my colleagues to reject this amendment, and I yield back.
Gentleman yields back. Does anyone else seek recognition? In that case, the question occurs on the amendment. All in favor say aye.
Aye.
Opposed, no. No.
Aye.
The opinion of the chair, the noes have it.
Mr. Chair, the yeas and nays, please.
The yeas and nays are requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Loughran.
No.
Ms. Loughran votes
All
no.
members will mute their microphones, please.
That was a big deal. Those wages need a transformative.
Ms. Jackson Lee.
No.
Ms. Jackson Lee votes no. Mr. Cohen. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch. Ms. Bass.
Bass votes no.
Ms. Bass votes no. Mr. Jeffries.
Jeffries votes no.
Mr. Jeffries votes no. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu. Mr. Raskin. Ms. Jayapal.
No.
Ms. Jayapal votes no. Ms. Demmings. Ms. Demmings votes no. Mr. Correa.
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath? Ms. McBath?
How is Gomer recorded?
No.
Ms. McBath votes no. Mr. Gomert, you are not recorded.
Okay.
Mr. Stanton?
Cohen recorded?
Mr. Cohen?
No.
Mr. Stanton votes no. Mr. Cohen, you are not recorded.
Cohen will vote no.
Mr. Cohen votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush?
Bush votes no.
Ms. Bush votes no. Mr. Jordan?
How is Swalwell recorded?
Mr. Jordan votes yes. Mr. Swalwell, you are not recorded.
No.
Mr. Swalwell votes no. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert?
How am I recorded?
Mr. Gomert, you are not recorded.
Okay, well, give me an eye, please.
Mr. Gomert votes aye. Mr. Isa? Mr. Isa, you are not recorded. Mr. Isa votes aye. Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey?
Aye.
Mr. Massey votes aye. Mr. Roy?
Aye.
Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach?
Aye.
Ms. Fishbach votes aye. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Mr. Chair, how am I recorded?
Mr. Liu, you are not recorded.
No.
Mr. Liu votes no.
Mr. Chair, how am I recorded?
Mr. Raskin, you are not recorded.
I vote no.
Mr. Raskin votes no.
Are there any other members who wish to be recorded who haven't been recorded? The clerk will report.
Mr. Chairman, there are 14 ayes and 24 noes.
The amendment is not agreed to. Are there any further amendments? If not, the question occurs on the amendment nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment nature of a substitute is agreed to. The recording quorum being present, the question is on the motion to report the bill H.R. 2873 is amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
The ayes have it, and the bill is ordered reported
Mr.
favorably.
Chairman. Yeah, Massey from Kentucky requests a recorded vote.
A recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee?
Is this a no?
This is final passage.
Oh, this is passage. I'm sorry. Aye.
Ms. Jackson Lee votes aye. Mr. Cohen?
We do have a higher percentage of women in the trade than
Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Stimmings? Ms. Stimmings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Steen?
Aye.
Ms. Steen votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones?
Aye.
Mr. Jones votes aye. Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye.
How is Swallow recorded?
Mr. Swallow, you are not recorded.
Aye.
Mr. Swallow votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Isa? Mr. Isa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy?
No.
Mr. Roy votes no. Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
No.
Ms. Sparts votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes no.
Mr. Chairman?
Mr. Gates, you are recorded as aye.
Mr. Chairman?
Mr. Gates votes no.
Mr. Chairman? Chairman?
Mr. Shabbat?
Yeah, how am I recorded?
Mr. Shabbat, you are not recorded.
No.
Mr. Shabbat votes no.
Mr. Cohen votes aye.
Mr. Cohen votes aye.
Mr. Chairman, how am I recorded?
Mr. Deutsch, you are not recorded.
Aye.
Mr. Deutsch votes aye.
This is Ms. Bush. How am I recorded?
Ms. Bush, you are recorded as aye.
Mr. Chairman, this is Congressman Buck. How am I recorded?
Mr. Buck, you are recorded as no.
I would like to change that to aye.
Mr. Buck votes aye.
Are there any other members who haven't voted who wish to vote? Mr. Owens?
Mr. Owens votes aye.
The clerk will report.
Mr. Chairman, there are 27 ayes and 16 noes.
The bill is, the ayes have it, and the bill is amended, is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. For what purpose does Mr. Cicilline seek recognition?
Mr. Chairman, I move to strike the last word with a point of personal privilege to recognize the contributions to the committee of Amanda Lewis, whose time on the committee as a detailee from the Federal Trade Commission is sadly coming to an end. For nearly 3 years, Amanda has served as an attorney on the Antitrust Subcommittee. During this time, she has spearheaded our efforts to lower America's healthcare costs. This important work includes the enactment of 2 laws that will save lives and billions of taxpayer dollars in the form of lower prescription drug costs, as well as the advancement of the legislation we have considered today. Amanda also has played a critical role during the committee's digital markets investigation, lending her tremendous enforcement expertise to every aspect of our work. Most recently, she was instrumental to the development and advancement of our package of bipartisan legislation to create more choice and competition online. In every case, she worked across party lines on some of the most technical and complex areas within the subcommittee's jurisdiction. We could not possibly have done this work without her. I want to thank her for all of her contributions on behalf of American consumers and small businesses, and on behalf of a very grateful subcommittee for all of her assistance, and we all wish her every success during the next steps of her career. Thank you, Mr. Chairman. I yield back.
Yes, and I want to add on behalf of all the members of the entire committee that we thank her for her invaluable contributions, and we wish her well in the future. Well, let's till tomorrow. So, come back. How many bills have we left? So let's do the recess and then finish the bill. Okay, and after the votes, we'll come back. There are floor votes now, and the committee will stand in recess until 10 o'clock tomorrow morning.